Meet please, Lordship.
Yes.
Well, the mention was made on Friday to list a matter today. Well, I was advised by the registry people to make a mention of that subject matter in the bench 5. I made it and it was allowed. Subsequently, it was registered as a bench 2 item. So it could not be listed today. So may I pray, my lord, if not inconvenient, a bit of urgency there. So if Lordship pleases, can it be taken up today itself, or if inconvenient, then tomorrow?
It's which bench matter? Bench 2 or bench 5?
Initially, I was advised that it is a bench 5 matter. But after at the time of registration, it is seen that it is a bench 2 matter. So it is registered as a bench 2 matter now. Therefore, even if my mention was allowed by bench 5 on Friday, it could not be listed today.
What is the matter? It's a motion.
Motion, fresh matter. A very fresh matter.
Let it come on Wednesday then, on a motion day.
What happened, my lord? We are a school, my lord, and we have 721 students, and around 56 teachers. And our bank accounts have been seized by the, freezed by the ESIC Corporation. And therefore, nobody is getting salary, neither we could pay the electricity bills. And therefore, it's exams, 6 monthly exams is going on. With urgency, that is why.
We'll have it on Wednesday. Tomorrow, we already have a list. Wednesday. Okay? On 18th.
18th, my lord, I have some difficulties. That is why I'm sincerely praying, my lord.
Then Friday?
It will be late, my
Friday.
lord. Can it be taken up tomorrow, my lord?
No, not tomorrow. Either you take it up or we take it up on Wednesday or Friday.
Friday, my lord. No, Friday.
20.
Mr. Shamua, let us have it on the motion day, okay? Wednesday or Friday. You take a pick.
Yes, my lord, Wednesday.
Wednesday, all right.
Yes.
All right, next.
My lord, I am praying for listing this petition, my lord. My lord, this petitioner was placed on a suspension. So, my lord, so cause has been issued to him. Almost, my lord.
It's a fresh matter.
Fresh matter, my lord.
Motion.
Admission matter, my lord.
Admission matter.
matter, my lord.
When was it last listed?
It was listed last on, my lord, 24/3/25.
So it was listed recently.
No, my lord, 3 months has already passed, my lord. No so cause issued, my lord. Suspension matter, my lord. That cannot be continued. On Friday, my lord, I'm not praying for Wednesday, my lord. It can be.
All right, Friday.
Fine. Obliged, my lord.
May I please, your lordship? Lord, I have prayer in item 41, my lord.
41.
Yes, my lord. I am for the respondent, private respondent, my lord. Respondent number 5, my lord. I filed my affidavit, my lord, on 19th of May, my lord. I have taken the consent from the petitioner. He's also here, my lord.
Which item?
Item 41, my lord.
41. What do you want?
Can it be listed after vacation? Today, I'm not feeling very well, my lord, physically. My lord.
Why is it come for orders otherwise?
I have filed, my lord, my affidavit, my lord.
When?
In opposition. On 19th of May, my lord.
19th of May.
Yes.
Who's for the petitioner?
The petitioner is
I am for the petition.
Yes, for the
Yes. So what do you say?
My reply, my lord.
You'll file reply.
No,
How much time?
2 weeks time, my lord.
Okay, list the matter again after the vacation. In the meantime, the petitioner is at liberty to file rejoinder affidavit, if so advised.
my lord.
May I please?
Briefly.
I beg to mention item 37 and 58, my lord. It may both the matters come after vacation, my lord.
Yeah,
In
mention one at a time.
My lord, in item 37, my lord, I shall file reply, my lord.
Okay, on the prayer of Mr. B. Prakash, learned counsel for the petitioner, list the matter again after the ensuing summer vacation.
It may come on 28th of.
Petitioner may file rejoinder affidavit. In the meantime, if so advised.
It may come on 28th July, my lord.
Why do you want a date?
Because by this time I'll file and it will be on that date.
No, it's okay. It'll come up after vacation. 37, then what is the other matter?
58, my lord.
58, similar order.
Obliged.
But 58 is a review matter.
A review matter. Review no, it's not before your lordship, my lord. It's an order of the retired.
Maybe. But
it will take time, my lord, and so it will.
Are you supposed to file a rejoinder in that case?
It is filed.
Okay, then not required. Then 58, you write separate order. As paid for by Mr. B. Prakash, learned counsel for the petitioners. List the matter again after the ensuing summer vacation.
It may come on 15th, my lord. It can be disposed of on that day. It may come ready for disposal otherwise.
Let us see how the registry fixes it. We will not fix a date.
Obligation.
May I please, Lord? Also, I beg to mention item number 13, admission matters. Lord, this matter become infructuous.
1-3.
1,
13.
yes.
Your good name?
80 Shokar.
Mr. A.T. Sharkar, learned counsel for the petitioner submits that the writ petition has become infructuous. In view of above, the writ petition stands disposed of as infructuous.
I beg to mention item number 7.
You are there?
I'm for the respondents, secondary education.
Then you write Mr. S.M.T. Chisti, learned counsel, learned standing counsel, secondary education,
Obliged, Lord.
appears for the respondents.
I beg to mention item number 7 of today's list, my lordship. Here, Mr. Engaged counsel and Islam is not well, my lordship.
Okay. On the prayer made on behalf of Mr. Islam, on account of being indisposed, matter stands adjourned for 2 weeks.
May it please your lordship. Lordship, I make to mention item numbers 38 and 39.
38.
38 and 39, lordship. They're with matters of today's daily list. Lordship, we have taken consent from the other side as well. Can this matter be taken up, if convenient to you, lordship, can this matter be taken up on the 26th of June, before vacations?
What is the inconvenience today?
Lordship, there are some instructions that we have to obtain regarding these two matters, and those are still awaited.
We'll have it on 25th.
25th,
Yes.
lordship.
Your good name?
M. Bhuyan, lordship.
You're for which party?
The Assam Science and Technology University, asked to.
You have taken the consent?
Yes,
Lordship, I am the petitioner, Lordship.
Okay.
K.M. Majumdar.
We'll have it on 25th.
They have to file their affidavit because of which.
On the prayer made by learned standing counsel, ASTU, and not objected to by the other side, list the matter on 25th of June 2025. Stop the respondent ASTU shall file affidavit on or before the next date.
Lordship.
May 38 and 39, Lordship.
Yes, 39 also same order.
May it please your lordship.
Yes.
Lordship, I beg to mention item number 46. Well, this matter has been wrongly tagged with item 44 and 45. The orders matters,
Which one?
46.
46.
Yes, my lord.
Yes.
My lord, last week this matter was listed and it was directed to be posted after 2 weeks.
Item 46.
Yes, my lord. It has been wrongly talked to these two number 44 and 45, my lord.
Yes,
This
sir.
may be details, my lord.
Yes, yes.
The date of the order, are you aware of the date of the order?
Last order, last date, my lord.
Date?
That I don't have, my lord. I have to check up. I'll give my lord.
But it was the last order, isn't it?
Yes, my lord. Last week it was came, my lord.
What is your good name?
I am TR Sharma, my lord.
Sorry?
TR Sharma.
TR. You're for which party?
I am for the petition.
Okay. Item 46, please write. Mr. T.R. Sharma, learned counsel for the petitioner, submits that the matter has been wrongly tagged with the other cases. Stop. He submits that in fact, the matter was directed to be listed again after 2 weeks, as per the last court's order.
On 9/6/2025, it was last.
9/6/25.
Yes.
Okay. Next para, in view of above, let this case be detached from the other cases and listed separately in terms of the order dated 9/6/2025. Okay.
I'm obliged. I'm sorry to trouble your lordship once again, my lord. On 18, some personal difficulties
Friday.
on my part. So, my lord, can it be on 19th? my lord?
What is 19?
19th is a Thursday. I sincerely pray, my lord, otherwise I would not have caused trouble to your lordship.
No, I already indicated to you, we'll have it on a motion day. Tuesdays and Thursdays are hearing days.
I
Mr.
understand, my
Chamwa.
lord, but this matter, my lord, a bit urgent, that is why I am pressing. my lord. Otherwise, I would not have caused trouble to your lordship.
You're very persistent, Mr. Shamu.
My lord, the situation is like that.
All right,
Lordship
all right,
got
all
not
right,
in conflict
all right.
at all, man. I sincerely apologize.
Don't take it as a precedent.
Of course,
19th, all right.
19. I'm sincere. Obliged.
Yes,
May I please, Lordship? I beg to mention item number 22 and 23.
22 and
23. And I have filed affidavit in reply today. Lordship, then it will be difficult to come today to the record of the honorable court. So it may be taken on next day.
you are for which party?
I am for the petitioner
You want it on a different date, why?
because today morning we have filed the affidavit in reply.
Reply. What's your good name?
Nayan Zemeti.
Mr. N.J. Mehdi, learned counsel for the petitioner, submits that he has filed the counter affidavit. No, he has filed the rejoinder affidavit this morning. And since the same is not tagged with the record today, he prays that the
Maybe
matter may be taken up after,
I'm for the respondent number 7 here.
taken up after a week.
Date may be fixed on 27th of June, Your Lordship.
After taking up.
27th.
It's the last working day.
It's the last working day.
26th
You know
was-
very well before vacation will be a motion week.
Vacation
They will
Before
come after the
vacation,
vacation. List the matter again after the vacation.
Obliged.
Please, Your Lordship.
Item 22 and 23, 24. No, 22 and 23. Two matters.
May I
Yes.
please, Your Lordship?
Yes.
No, I beg to mention for listing, my lord, for admission, my lord.
Hmm.
Pensionary benefits matter, my lord,
Hmm.
for on 20th of June, my lord,
20.
20, my lord.
All right.
Much obliged.
Yes, please, Your Lordship, I beg to mention for listing of a matter regarding non-payment of salary, Lordship,
Hmm.
petition colon. Lordship, any short date given? Can it be on 18, Lordship?
What is the urgency?
Urgency is the non-payment of salary, Lordship.
Hmm. When was it last listed?
9/5/2025.
9/5.
9/5.
Oh, in May.
3 weeks already.
Or
gone,
maybe
Lordship.
3 weeks. There are other cases we're waiting for the last 3 years. This will come after vacation, madam. Okay? Yes.
May I please, Your Lordship, my prayer is for listing, Lordship, WPC Lordship, and matter regarding pension matter, Lordship. So the matter was last listed in the month of January, Lordship.
Now, counter affidavit has been filed?
Lordship,
Counter affidavit filed
Lordship.
or not?
Yes, Lordship,
It has been filed.
Lordship,
She will have it immediately on our reopening.
Lordship.
Okay, on 14th of July. Right.
Lordship.
May I please, Your Lordship? Lordship, I beg to mention item number 14 of daily list.
14.
Lordship, matter has become infructuous.
Item 14.
Yes, Lordship.
14.
Yes, Lordship.
What is your good name?
M. Alam on behalf of M. K. Hussain.
Mr. M. Alam, learned counsel appearing on behalf of Mr. M. K. Hussain, submits that the matter has become infructuous. In view of above, the case stands disposed of as infructuous. You are there? Who's there?
PK Bora.
Mr. P.K. Bora, learned standing counsel, elementary education, appears for the respondents. Yes.
May I please, Your Lordship?
Yes.
I am praying for listing of two similar matters. The matters relating to non-payment of fixed pay.
When was it last listed?
Lordship, your last posted on 4/6/25.
4/6, very recent, madam. We'll have it after reopening. Okay. We'll have it on. Okay, you have it on 14th of July.
Obliged, Your Lordship.
Hmm.
May
Yes.
it please, Your Lordship, I beg for listing, Lordship, one WPC number. Lordship, matter relates to pensioner benefits, Lordship. Last listed on 21/8/2024, Lordship.
21/8/2024.
24.
It can wait for some time. Immediately after opening, we'll have it. Same
In-
14th.
Next week, petitioner is retired on 2019.
No problem, madam, is that, see, vacation is coming up, so the week will be declared as a,
Lordship
not possible.
is retired on 2019 Lordship. Till date, no counter affidavit also has been filed Lordship.
Counter not filed,
Filed Lordship.
filed.
Filed Lordship.
Okay, we'll have it on Monday then, on 23rd.
Obliged
All
Lordship.
right.
May I please, your lordship? I beg to mention for WPC number 227 of 2025. Kindly the matter may be listed on 26, 2025. The matter was last posted on 24/1/2025. Since then, the matter has been pending.
Counter has been filed? Not yet. Okay. All right, we'll see on 23rd. 23rd of this month.
May I please, your lordship?
Yes.
Your lordship, I pray for listing of a writ petition which pertains to family pension, your lordship. The matter was last listed on 26/3/2025. The matter is fixed for orders, your lordship. I pray any date, your lordship.
25th.
Much obliged, your lordship.
My lord, this matter relates to compassionate appointment, my lord. Recently, my lord, we have filed review against the dismissal order. Initially, this petition was dismissed on 23/2023. And thereafter, we preferred a review petition against the order passed by this honorable court. And accordingly, my review has been allowed, my lord. Whether that order is there or not.
So what is to be done today?
My lord, in review petition, it is admitted by the departmental authorities as well as by the honorable court also that while dismissing my writ petition, while rejecting my claim by the DLC,
It's a compassionate appointment.
yes, my scheme has been not followed. And
And your writ petition was dismissed.
we have filed review petition.
It has been revived.
Revived.
Okay.
Only on the ground that while rejecting my claim by the DLC, the scheme which was in force has not been followed. Kindly look at paragraph 16 and 18, madam.
16 of?
That review order, madam, whether that review order is there or not.
Please read.
My lord, 16 onward, my lord, 16, clause 15. My lord, from 1 to 15, there's a details. Paragraph 15, review file, paragraph 16. That is the OM 15 of the said office, madam, that so and so. If sufficient vacancies are not available in any particular office to accommodate the person in the waiting list for the compassionate appointment, it is open to the administrative department to take up the matter with other department of the government to provide at least early appointment on compassionate grounds to those in the waiting list. Then 17, clause 24 of that OM provides that while disposing of the application by way of rejection, clear speaking order shall be recorded stating the reason of rejection, and a copy of such order shall be furnished to the application. 18, paragraph 18, on 14/7/2015, the DLC Lakhimpur for compassionate appointment, when took up the case of the petitioner for compassion appointment on compassionate ground under die-in harness scheme, the said DLC was required to comply with the provision of the said OM dated so and so, which was very much in force, but it is seen that the DLC for compassionate appointment Lakhimpur in its meeting dated 24/7/2015 did not comply with the provision of the clause 15 of the said OM, nor it complied with the provision of clause 24D of the said OM dated so and so. Mr. Deuri, the government advocate, on instruction submitted that the DLC Lakhimpur in its meeting did not follow the provision of the said OM dated so and so. Paragraph 15, for such non-compliance of the provision laid down by the state government in its office memorandum relating to the appointment on compassionate ground of the dependents of state government employees who die in harness by the district level committee for compassionate appointment while rejecting her case on 24/7/2015. And for this reason above, the court found that the petitioner could place sufficient ground for review of the order dated so and so passed by this honorable court in accordingly the order dated passed by this honorable court is restored to the file. So my humble prayer would be that in terms of that WAM, my lord, I have the WAM.
Let us, let us see that order dated 23/23.
Yes,
Why it was dismissed?
my lord, only on the ground that order is there, my lord. Yes,
Yeah, I got it.
yes.
Now, what is to be done now?
My lord, only direction will be issued to the authorities to place the matter before the DSP.
Was counter affidavit filed? Has counter affidavit been
My lord,
filed?
in the review petition, they have filed, my lord.
Not reviewing the writ petition.
In the writ petition, they have not filed.
Huh?
Only on the ground that on 3 occasions, they have stated that my case was placed and on. in the
No,
year
you
to-
please answer the question I put to you.
Yes,
Has counter affidavit been filed in the writ petition?
no, my lord, that is not
Then-
right.
Yes, what do you say?
Lordship, our stand will be same as we had done in the, we have made in the review petition.
Okay.
So seeing the matter at hand, your lordship, so it may be remanded back and maybe placed in terms of that clause 15, maybe remanded back.
Oh, you agree with that?
Yes, I agree.
Okay. What is that you're passing me?
My lord, that OM, my lord.
Huh?
OM, my lord.
Not required. Don't give me that.
Similar order, my lord, in referring the matter under clause 15.
Not required.
Yes.
Don't give me that. What is your good name?
And Sharma.
Please write down. Heard Mr. N. Sharma, learned counsel for the petitioner, and Mr. B. Diori, learned
Junior government advocate.
junior government advocate for the respondents.
For this. For respondent number 4.
Okay, for respondent number 4. And
That's about
4 and 5. Okay. Anybody else? Also heard Miss K. Bora, learned standing counsel, elementary education department for respondent numbers 1, 2, and 3. We'll stop next para. Although this writ petition is listed for motion, but having regard to the nature of the case projected by the petitioner, comma, the writ petition is taken up for disposal at this stage. We'll stop next para. The writ petition earlier was dismissed by order dated 27/1/2023.
2023.
Mr. Counsel, I'll ask you if I require help. Okay, please take your seat.
Yes.
Was dismissed by order dated 27/1/2023 on the ground that there was no vacancy as per the quota meant for compassionate appointees. Stop. Later on, the petitioner filed a review petition number 55 of 2024. And this court, having regard to the office memorandum dated 1/6/2015, more particularly clause 15 of the said OM, recalled the earlier order dated 23/2023. To stop, it was observed that clause 15 had not been complied with, along with clause 24 bracket small d, D for Delhi, of the same OM. To stop. Stop. Having regard to the observations made by this court while recalling the order of dismissal of the writ petition, the learned counsels for the petitioners submit that the matter may be remanded back to the DLC concerned for fresh consideration in terms of the office memorandum dated 1/6/2015. Full stop. Next para, in view of above, the writ petition stands disposed of by remanding the matter to the district level committee for compassionate appointment, Lakhimpur, Assam, bracket respondent number 4, for considering the case of the petitioner for compassionate appointment in terms of the office memorandum dated 1/6/2015. Who will place before the DLC? Director or the district elementary education officer?
District Elementary Education Officer.
Of the district elementary education officer, bracket, not bracket, Lakhimpur, North Lakhimpur, Assam, bracket, respondent number 3, is directed to place the case of the petitioner before the respondent number 4 for fresh consideration as directed herein above within a period of 3 weeks from the date of receipt of a certified copy of this order. Okay.
May it please your lordship. In this matter, my lord, the present petitioners was earlier appointed in 1991 to 1994, my lord, and thereafter their services were regularized. Thereafter, a Monoharan committee has been instituted, my lord, for verifying the access teachers and other illegal and irregular teachers. The Monoharan committee has submitted its reports, my lord, and thereafter this 117 number of teachers in Nagaon district has been cleared, and their service was re-regularized in 2005, my lord, under the contributed pension scheme. Thereafter, out of 170 number of teachers, my lord, 39 number of teachers had approached before this honorable court, my lord, claiming old pension scheme. And this honorable court, basing on a order passed in a review petitions, my lord, held a view that they are entitled for an old pension scheme, my lord. Thereafter, another batch of 36 number of teachers, including other teachers, also approached on with the same prayer, my lord. And thereafter their writ petitions are dismissed. Thereafter they file an appeal, my lord. And during the pendency of the appeal, a decision has been taken up by the government in a meeting that the persons whose service was regularized or appointed after 2005, but their process was started before 2005, my lord, their services will be taken into account under the old pension scheme. And the basis of that or decision, my lord, those appeal has been disposed of. First of all, your lordship, I have to beg your lordship attentions to the order of this honorable court, first order of this honorable court, which was passed in the case of 39 numbers of teachers whose services were re-regularized in 2005, along with the present petitioner, my lord. That is at page number 104, my lord. And the relevant portion is started from page number 112. From para 6, my lord.
Have you filed the additional affidavit?
My lord, I have filed.
You have filed.
Yes, my lord. In that additional affidavit, I have bring all the details about the teachers who filed earlier to writ petitions and their positions in the list, my lord, along with the position of the present petitioner in the said list.
You're showing me an extra 7.
Yes, my lord.
Are you saying that you're covered by this order?
Yes, my lord.
You're covered by this
My
order.
lord.
What was the direction?
Direction is at page number 112, my lord. May I read, my lord? From paragraph 6.
Yes.
As indicated above, the issue involved has already been decided by this honorable court via the judgment dated 28/4/2015, passed in WPC number 3662/2009. It has been held that the NPS would not be applicable to the petitioners whose services were regularized prior to the amendment of the 1969 rules. It may be mentioned that the judgment order dated 28/4/2015 passed in the aforesaid writ petition was the subject matter of review in review petition number so-and-so. And this court, via an order that so-and-so had dismissed the prayer for review in the following manner. In the present case, the petitioner services having been regularized on 4/6/2008, the petitioners become regular government servant on 4/6/2008. And as the 1969 rules was in force at that relevant point of time, the executive instruction issued could not have overridden the statutory law. As such, this court had accordingly directed that the petitioners would be governed by the 1969 rules and not by the new defined contribution pension scheme, which came into force only by way of amendment of the 1969 rules in the year 2011. In the case of Dilip Kumar Ghosh versus Chairman, reported in 2005-7 SCC 567, the Apex Court has held that circular, notification, administration, executive instruction, order, etc. cannot be override statutory rules. This is about the review petition, my lord. On the basis of this order, my lord, in next paragraph 7, it is accordingly submitted at the bar that the aforesaid judgment 28/4/2015 has not been challenged in any higher forum and has attained finality. In view of the above, this court is of the view that the present two writ petitions can be disposed of in the same line of the order dated 28/4/2005 passed in WPC number so-and-so by holding that the petitioner would be governed by the Assam Service Pension Rules 1969 and not by the NPS. With the aforesaid direction, both the writ petitions stand disposed of. One of the writ petition is filed by 39 number of teachers, my lord, whose name was whose services were regularized along with the present petitioner in the same list, my lord, 117 list, my lord. And recently also, my lord, government has decided in a meeting to brought all the appointments which process was started from before 2005, my lord, under the old pension scheme, my lord.
When was your service regularized?
2005, my lord. Along with the petitioner of this writ petition, my lord. There are two writ petitions, my lord.
2005, you say?
Yes, sir.
And when was the amendment?
Amendment is 2011.
Of amendment of 1969 rules?
Yes.
2011.
11. It is indicated in the order itself, my lord. And in the additional affidavit, my lord, I have in a developed for manner, my lord, name all the petitioner of the said writ petitions and their position in the list, my lord.
So this set of writ petitioners, which you are claiming you are similarly situated.
Yes, ma'am.
This is a common order, is it?
Yes, there are two.
A common judgment.
Yes, there are two writ petition, my lord.
Okay.
And the writ petitions, which I have relied upon, my lord.
This is the review. You just read review, isn't it?
No, it's not review. Review order has been taken into account, my lord. That review order was passed in earlier, which has decided whether the rule will prevail over the circular or notifications, my lord. And in the review, it is decided that rule will be prevail on the circular or notification.
What is the case number? 8694.
7873 of 2015, my lord.
78. Where is that?
In page number 106, my lord. And I have also annexed the order of the review petition, my lord.
It's a link case. 7873 is a link case.
787, there are two cases in this order, my lord. One is 8694/2018 and another is 7873/2015.
Common
The
that.
first one was filed by some employee from Kamrup district, my lord.
Common order.
Common order, my lord. And the petitioner of the 7873 of 2015 are those persons whose services were regularized along with the present petitioner, my lord, by a common order, my lord.
And review was in case of review of which order?
Review order is at page number 91, my lord, wherein it is decided the regularization of 2008 persons who are services were regularized in 2008 will be brought under the old pension scheme or not, my lord. That is a
No, review of which order?
review of that order. I have not annexed, my lord, but that order is, my lord, 28/4/2015 passed by this honorable court in WPC 3662/2009, my lord.
Yes, what was that?
That order I could not annex here, it, my lord.
But you must tell me, what is it about?
The regarding, my lord, in that case, my lord.
What was the order passed in 3662?
In that case, my lord, what happened, my lord, some drop teachers were regularized in 2008, my lord. And they are brought under the new pension scheme. They filed the writ petitions claiming old pension scheme. That writ petition was allowed, my lord. Against that writ petitions, the state came up with a review petition, my lord. And that review petition was dismissed with the observation which is started from paragraph 9 of the review order, my lord.
The review was dismissed.
Yes, my lord. Affirming the writ petition.
The review is by the state.
Yes, my lord.
Just read that. Page 100.
102, my lord.
No, read page 100.
100.
Second paragraph.
Yes, my lord. The review petitioner are praying for review of the order dated 28/4/2015 passed by the court in WPC number 3662/2009. Wherein this honorable court had directed that in view of the judgment and order dated 1/9/2003 passed in CR number so, the writ petitioners were to be given the pensionary benefit as per the Assam Service Pension Rule 1969, and that their post services should also be counted for the purpose of commutation of pensionary benefit in terms of the Assam Service Pension Rule 1969. Mr. K.P. Pathak, the learned counsel for the review petitioner, submit that a review has become necessary in view of the fact that while the petitioner service had been regularized on 4/6/2008, the new defined contribution pension scheme had come into force with effect from 1/2/2005 in terms of the letter dated 25/1/2005 issued by the Commissioner and Secretary to the Government of Assam Finance Department and the Office Memorandum dated 6/10/2009 issued by the Government of Assam Finance Budget Department. He also submitted that a state respondent can make a law with retrospective effect, and the same would be applicable unless it affects the vested rights already occurred. Accordingly, the Assam Service Pension Rules 1969 was amended on 14/7/2011 by the Assam Service Pension Amendment Rules 2011, hereinafter referred to as Pension Amendment Rules 2011, which was given retrospective effect from 1/2/2005. Mr. A.C. Borbora, the learned senior counsel for the writ petitioners, opposite party, submit that in terms of direction number 6 passed by this honorable court in CR number 1571/1998, the state respondents had been directed to make a list of drop teachers eligible for regularization, and they were to be regularized with prospective effect with the benefit of counting their past service for the purpose of commutation of pensionary benefit. As the petitioners were regularized on 4/6/2008, when the Assam Service Pension Rules 1969 was in force, the writ petitioner had to be given their pension in terms of the 1969 rules. Accordingly, the impugn order dated 28/4/2015 passed in WPC number 7 need to now review. I have heard the learned counsel for the parties. This court in the impugn order dated 28/4/2015 had, in pursuant to the direction number 6 passed in CR number so, directed that pension was to be given and the benefit of past service was to be counted for the purpose of commutation of pensionary benefit in terms of Assam Service Pension Rule 1969. The service of the writ petitioner to regularize on 4/6/2008 when the Assam Service Pension Rule 1969 was in force. The new defined contribution pension scheme came into effect by way of the Assam Service Pension Amendment Rules 2011, by notification dated 14/7/2011, with retrospective effect being given from 1/2/2005. Thus, it is clear seen that on the date the petitioner services were regularized, the 1969 rules had not been amended. This court has no quarrel with the proposition that legislatures and competent authority under Rule 309 of the Constitution of India have the power to make law with retrospective effect. However, this power cannot be used to deprive the writ petitioner of their right to be governed by the 1969 rules. The letter dated 15/1/2005 issued by the Commissioner and Secretary to the Government of Assam Finance Department states that government servant joining the service of the state government on or after 1/2005 shall not be governed by the existing Assam Service Pension Rules 1969, an order issued thereunder from time to time. So far as their pension and other retirement benefits are concerned, they will be governed by a new state of pension rules, which are being formulated in line with the contributory pension scheme announced by the Government of India recently. The OM dated 6/10/2009 issued by the Government of Assam Finance Budget Department provides that silent features of the new defined contribution pension scheme and also state that the same would be applicable to all new entrants joining the state government service on regular basis against vacant sanction posts on and after 1/2005. In the present case, the petitioner service have been regularized on 4/6/2008. The petitioners become regular government servant on 4/6/2008. And as the 1969 rules was in force at that relevant point of time, the executive instructions issued could not have overridden the statutory law. As such, this court has accordingly directed that the petitioners would be governed by the 1969 rules and not by the new defined contribution pension scheme, which came into force only by way of amendment of the 1969 rules in the year 2011. In the case of Dilip Kumar Ghosh versus.
Okay, I think you can stop there. Petitioner's case was that they were regularized on 4/6/2008.
Our case in 2000.
Not your case, in this case, which you
Yes,
just
right.
read. In your case, you were regularized in 2005.
Prior to that.
Prior to that, 2008.
Mine.
And according to the review court, amendment came in 2011.
Mine.
Later on.
Mine.
So he cannot be governed by the new pension rules. So that is where the matter lies. What do you say?
My lord, here, my lord, at this stage, notice may go, I will take instruction on whether they will come under that category or not, my lord.
My lord, I
Considerable
in
category.
the additional affidavit. Prior to this review order, I have referred an order passed by this honorable court relying on this review order, wherein 39 teachers has been given the benefit of old pension scheme. That 39 teachers services were regularized along with the present petitioners by the same order.
And
From the same list.
Which order? Annex 7?
My lord,
Your
that.
what have you filed in your additional affidavit?
Additional affidavit, I have given the status of the teachers of the petitions of the present writ petitioner, my lord. I have in the order which I have referred as the annexure 7, my lord, that is the order, my lord. In page number, my lord, 152 of my additional affidavit. These are the teachers. My lord, these are the teachers who instituted the writ petition, my lord, WPC number 7873/2015. Wherein this honorable court passed an order relying on the review order that I have referred, my lord. These are the teachers and their serial number in the list as well as the page number in the writ petitions I have been mentioned.
What is the writ petition?
Numal Chandra Bordoloi.
No, writ petition number.
Writ petition number 7873/2015, my lord.
So these people in the list, they are the petitioners therein.
They are in, my lord.
How many of them?
39.
30?
39.
39.
Yes, my
And
lord.
what is this serial number in the list? Which list?
List is at page number 81 of the writ petition.
What is that? What is that list?
This is the list, my lord, 117 number of teachers whose services were regularized, my lord, in 2005. The present petitioner's name were also, except one, my lord.
This list of Nagaon district, my lord.
Nagaon district.
We are also,
Nagaon district.
we are also.
But where's the beginning?
No beginning.
Beginning is from order. I have annexed the order from 76, my lord. 76, my lord.
76.
That is the order, my lord. In excess, in first paragraph, it is written, my lord. The next is the conferred under, upon the Director of Elementary Education Assam by the government under letter number so and so, and in pursuance of the government order under memo number so and so issued on the decision of the cabinet of the cabinet meeting held on so and so for regulation of service of 2,776 so and so teacher of the state who are appointed in excess post during the period of so and so and which were inquired into by one of the committee so and so so and so so and so department screening. The service of 117 number of ME, MV, MEM senior basic government basic working teacher in the district of Nagaon are hereby regularized with effect from the rate of their joining against the vacant post as per enclosed list. This is the list, my lord. 170 number.
List is at page 81.
81, my lord. Here, my lord, there are.
You're also there in that list.
Yes, my lord. Yes.
What is your position?
Our except one, my lord.
How many petitions in all?
Here, my lord, we have
11
petitioners.
11 petitioners.
10 petitioners' name is there, but one was dropped in the list. Her service was regularized later on. Our position is, my lord, at
Which is that person who was regularized later on?
petition number 7, my lord.
Petition number 7.
My lord.
When was
2006, my lord. That is also before 2008, my lord. I have an regularization order.
Can you give the date, particular date?
Our services were regularized, my lord, on 4/2/2006.
And the remaining?
Remaining, my lord, in petitioner number 1, his name was at serial number 20 of the list. Page number 150, my additional affidavit.
Remaining have been regularized by this order.
Yes, my lord.
17 August.
Yes, my lord.
With effect from?
That was joining against the hereby regularized with effect from the date of their joining against the vacant post as per enclosed list.
So can we not say that let it be examined? There are so many people who have been regularized as per this order.
My lord.
Petitioners, they say that their all name also appears except for petition number 7, who was regularized in 2006. But whatever it may be, regularization happened before the amendment of 2011. So if they are found to be regularized indeed, and if they are also similarly placed with the others, similar benefits should be given to them.
Recently, my lord, coordinate bench of this court, my lord, in Purnima, Horo and others, my lord, passed in judgment that only stipend teachers who were stipendiary teachers, they will entitle for pension only, my lord. Others are not, my lord.
Finance is the necessary party.
And also, finance is a necessary party. Finance is not a party here, my lord.
That will come on later on after they will decide whether we are entitled or not, my
My
lord.
lord, here at this stage, notice may go, my lord. Let us verify.
Common order, my lord, the service order has been passed and that apart, my lord.
See, the thing is that when some others have already got the benefit, what is the point of
We
keeping
have
it
to
pending?
verify, my lord.
You will all verify whether they are also similarly situated.
Verify it, my lord.
If they are not similarly
The
situated, then
benefit will be given by the finance department.
that you will write to the finance department.
My lord.
The finance department will not verify, isn't it?
My lord.
This is your department. First, you will verify whether they have been appointed and regularized within a certain period of time,
My lord.
My lord.
similar to those people in that writ petition.
My lord.
If they also have been appointed as such and regularized as such, then they are entitled to get the
A
benefit.
short date may be granted to take instruction. A short date may be granted. Because my lord, here, my lord, petitioner, some of the petitioner from Morigaon district and some of from
My lord,
Nagaon district.
This matter was 2024 in the first day.
True, my lord, notice has not been issued till
My
yet,
lord,
my lord.
on the first order, my lord, time was taken to take instructions, my lord, into.
See, we are talking about which district now in this case?
Nagaon.
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 Morigaon also there.
No, no.
Only Nagaon,
Nagaon.
not Morigaon.
Not Morigaon, my lord. All are teaching at school in Nagaon district, my lord.
This order at page 76, it pertains to Nagaon only.
Nagaon. The earlier writ petition, my lord.
Page 76.
76. Nagaon. Nagaon.
It pertains to only Nagaon.
Nagaon. And list also clearly stated, my lord, ME school teachers of Nagaon district in 81 patients. They may verify it if we are entitled, my lord, they may proceed. If not, my lord, keeping this.
That's what I'm
petition
saying.
will not serve any purpose.
We're not simply saying that give them the benefit. You will
No.
verify.
If we are
Also,
If they are similarly placed, then they should get the benefit.
one more chance may be given. I'll take detailed instruction from the authority, my lord.
What kind of instructions?
Whether they are entitled or not, my lord.
That you'll find out instead of keeping it pending.
My lord.
We'll ask the authorities to examine it and find out whether they are entitled to or not.
My lord.
I'm not saying that they are automatically entitled.
My
You will verify.
That will verify, my lord.
In the light of Purnima horror also, my lord, there is.
Heard Mr.
MAI Hussain.
M.A.F.
MAI Hussain.
M.A.I. Hussain, learned counsel for the petitioners, and Mr.
P.K. Bora, my lord.
P.K. Bora, is it?
My lord.
Learned standing counsel, elementary.
My lord, I'm for all the respondents.
Education Department. So having regard to the nature of the case projected by the petitioners, the writ petition is taken up for disposal at this stage. We'll stop next para. It is the claim of the petitioners that they are similarly situated like those of the 117 school teachers of Nagaon district who were considered for being covered by the Assam Services, open bracket, pension, close bracket, rules 1969, open bracket, rules of 1969, close bracket, full stop. Two set of writ petitioners approached this court by filing WPC number 8694 of 2018 and WPC number 7873 of 2015. So both the writ petitions were disposed of by a common order dated 12/8/2021. By relying upon the earlier judgment rendered by this court on 28/4/2015 in WPC number 3662 of 2009. Wherein it was held that the new pension scheme would not be applicable to the petitioners whose services were regularized prior to the amendment of 1969 rules. Stop. In fact, the review petition filed by the department, that is reviewed petition number 16 of 2019, was also dismissed by this court by order dated 11/2/2021. Full stop. The learned counsel for the petitioners therefore submits that the present petitioners are squarely covered by the said decision. And their names appear. Where is that
List,
76, isn't it?
yes, my lord.
Their names appear in the order dated 17/8/2005,
My lord.
issued by the Director, Elementary Education. White memo number EM-48/2005/13. Most of that in respect of respondent number 7. 7 is he or she.
She, my lord.
She was regularized on 4/2/2006. Stop. Next para. Having regard to the above projection, the writ petition is disposed of with a direction to the respondent authorities to examine the case of the petitioners as to whether they are similarly placed with the petitioners in WPC number 8694 of 2018 and WPC number 7873 of 2015. Full stop. Upon such verification, if they are indeed found to be similarly placed, the petitioners shall be given similar benefit as was extended to the petitioners referred to herein above by granting them pension as per the rules of 1969. Such exercise be initiated and completed within
In the
a
light
period
of, my lord, I'm in the light of Purnima Hor and others reported in 2023, my lord. There is a guideline, my lord, that in
Where is
Purnima
that?
Hor
Huh?
will be entitled, my lord, in Purnima Hor case, my lord, reported in 2023 SCC online GU 1165.
If I am not wrong, my lord, that order has been challenged in a writ appeal and that may be pending, my lord.
No.
Subject to correction, my lord.
No stay order is there, my lord.
That is pending, my lord. That order was sailed before the division bench of this honorable court, and that apart in recently, my lord.
Here, my lord, numbers of petitioner challenged regarding, my lord, pension under the old pension scheme, my lord. They are appointed after.
Who has
2000
challenged? Department has challenged.
My lord, not my lord, petitioner, number of petitioners challenged their appointment, who have appointed after 2005, who are granted my new pension scheme. They want my own pension scheme. Thereafter, Purnima Horo case was, order was passed by this coordinate bench of this honorable court that only stipendiary teachers will be entitled for the pension under the old pension scheme, not the drop teacher and other illegal and irregularly appointed teachers, my lord. They may,
That of course you will examine.
Yes, and,
in the light of Purnima Horo, that may be recorded, my lord.
but it is a and in this regard, my lord.
Well, in this case, my lord, this review petition and all this case has been discussed, my lord.
In this regard, my lord, that order is said before this honorable court. That is one aspect. Ma'am. Another aspect is that during the pendency of those writ appeals, my lord, the government have in a meeting decided to give the benefit of old pension scheme to the persons, although whose regularization or appointment, whatever it may be done before 2005. But the process was started before 2005. In this regard, I have annexed the minutes of the meeting, which is at page number 131. That also be taken into account, madam, because this is the decision of the government, or 131, madam, page number. That was a meeting held on 15/2024, madam. Let them verify all these things, my lord. Some will get, some will not get.
Minutes of the meeting dated 15/3/2024.
2024, you are in the resolution number 1, my lord. The government of Assam will consider extending the benefits of old pension scheme to those employees who joined the government service after January 2005. But the recruitment process for the concerned post was started prior to January 2005, in line with the recent OM issued by the central government. So on this,
this my meeting minutes, where from they have received, this was a personnel department. Personnel department is not a party here,
but let them verify it, my lord. Let them verify all these things, my lord. I am not seeking that your lordship pass an order directing them to grant us old pension scheme. Let them verify it, my lord. After verification, so if we are not entitled, then okay. If you are entitled, then did I? Your lordship,
That direction I've already passed.
my lord,
Now, what all aspects have to be looked into?
my lord.
He's referring to one case.
Yes.
Should we include that?
my lord.
That case is
You're aware about that case?
I am not aware of that case because, my lord, although I know about this matter, my lord, but I am not gone through that order, my lord.
That Purnima Hora case, that is the main base. The series of cases were taken up, more than 100 cases. And that Purnima Hora judgment that was passed by the coordinate bench, that is a benchmark and that is followed by the department of justice. And though it has been challenged by some petitioners, but no stay order has been given.
That is one
thing. Purnima Hora case, that is the most important.
And when the appeal challenging
everything was done, Lordship, it is a stand of the finance department. On the basis of stand of the finance department, that judgment was passed.
What was the decision in that case?
In that, only stipulated teachers, they were entitled for OPS, Lordship, not all other teachers.
And just I have referred.
What are you? Are you not a stipended teacher?
No.
You're not a stipended.
We are not. Earlier petitioners are also not, my lord. So, my lord.
And whatever the review, my learned friend has been referred, everything has been discussed in Purnima Hora case, Lordship.
No, but has this judgment been overturned?
Purnima Hora, no, not yet, Lord.
No, in
my lord can
Sukumar Sarkar's case.
My lord can do one thing, my lord. If your lordship is going to include the Purnima Hora case, your lordship may take also note of this meeting also, that also be verified, my lord, because this is the decision of the government. And on good land, on the basis of this decision, my lord, some cases were processed, my lord, with the land. So,
what was the last line?
This minute cannot be.
What is the last line?
On the basis of this minor, batch of retail has been disposed of. So,
3 months from the date of receipt of the certified copy of this order. To stop, it is further provided hearing that the respondent authorities shall also take into consideration the decision taken in the shall also take into consideration the minutes of the meeting held on 15/3/2024 in the conference hall of the Honorable Chief Minister Assam under his chairmanship.
And an order, my lord, pass on the basis of that meeting, my lord.
A copy of which has been annexed to the writ petition as annexure 9.
Well, this meeting minus which he is referring, page 35.
135.
Yes.
Here, bearing the signature of Honorable Chief Minister.
What is the source? How he has got it?
And that on the basis of that, my lord, minutes, batch of retail has also been, my lord, disposed of, my lord. I have annexed that order also, my lord. That also taken into account, my lord.
What is that
How
case?
can he record this letter, my lord? What is the source of record?
That case number which you just referred to.
My lord. Purnima Horo and another versus State of Assam and others. Reported in 2023 SCC online GU 1165.
2023 SCC online
GAU
GAU
1165.
1165. Purnima
Hore.
Hore.
SORE and others.
Versus State of Assam and others.
Others. WPC number 6403 of 2021.
WPC
6403 of 2021. Man.
So we incorporate this also.
My lord.
The respondent authorities shall also take into consideration the case of
My lord, only my humble prayer is that my lord, this may be recorded, my lord, how from his letter has this minutes are received, my lord. Bearing signature honorable chief minister, my lord.
what did I say? Take into consideration before that. Which is the next test. You want me to record your objection?
My lord, yes, regarding this, my lord, meeting minus one. This is an internal document where from he has received, my lord.
Bracket open, open the bracket, the source of which is objected to by the learned standing council, elementary education.
Meeting minus dated 15/3/2024.
Then the next sentence, the respondent authority shall also take into consideration the case of Purnima Hore and others versus State of Assam and others. Bracket WPC number 6403 of 2021, close bracket, which is reported in 2023 SCC online GAU 1165. All right.
God bless.
Lordship, I have received instruction. I shall file affidavit, Lordship, for that may be given after vacation, Lordship, I shall file.
My lord, this matter pertaining to lordship promotion to the post of headmaster lordship. Lordship, the authority lordship has lordship selected the private respondent lordship by violating the rule 14.
Lordship, I received instruction, Lordship, Lordship, I need to file affidavit, Lordship.
My lord, by violating the rule 14 of the Assam Service Provincial School Rules of 2018 lordship. And lordship, last week lordship, similar situated petition case of the like of the petitioner lordship have been disposed of lordship and directing the authority lordship. Lordship, this is the order lordship.
No, Lordship, I have gone through it, Lordship.
Lordship,
Lordship,
this is a forward case lordship.
select list is in the year 2024, Lordship, March 24, Lordship. Now June 25, Lordship.
Lordship, private respondent, they are the much junior to the petitioner, Lordship. Those who are working in Lordship, only Lordship, a length of service of private respondent, Lordship, only
Your-
10 years,
Lordship, I
10 years,
file
12
affidavit,
years,
Lordship.
13 years, 13 years, 17 years. Even the Lordship petitioner
ACR is not.
is
good,
a
Lordship.
head. Yes,
You don't counter like that straight away.
yes, Lordship.
You please explain your case.
Lordship,
Yes.
yes, so Lordship, the case of the petitioner, Lordship, he has been to Lordship, he has been drawing the gazette scale of pay Lordship from the period of 1998 Lordship. Lordship, I am referring to less.
No, what is the petitioner? He's a teacher,
Yes, Lordship.
graduate teacher,
Gazette teacher, senior most gazette teacher, Lordship.
senior most.
Yes, Lord, senior.
And what is the next promotion?
To the post of a headmaster, Lordship, of high
Headmaster.
school. Yes, Lordship. And Lordship, one graduation list is prepared by the school inspector.
Your case is that those who are junior to you have been promoted
Yes, Lordship.
without considering your case.
Yes, Lordship.
What is the criteria?
Lordship, yes, Lordship, Rule 14 of the Assam Provincialization Service. Assam Secondary Education Provincialization School Rules 2018. Lordship, Rule 14, Lordship.
You should have abstracted that in your writ petition.
Yes, Lordship.
Have you abstracted?
Yes, Lordship. I have,
Where?
Lordship, internally page 15, Lordship, paragraph 12, Lordship.
15. Rule 14.
Yes, Lordship.
Please read.
Yes. Recruitment to the post of headmaster, public superintendent, and procedure thereof. Number one, the post of headmaster of a high school and superintendent of a high madrasa shall be filled up by promotion from the candidates among the graduate teachers as per district-wise seniority list on the recommendation of the district selection committee constituted under Rule 16(2). The selection of a headmaster and superintendent shall be based upon seniority and a satisfactory annual confidential report for last 3 consecutive years as per procedure provided under sub-rule 3. Provided that the seniority of graduate teacher shall be determined from the date of receiving graduate scale of pay by respective assistant teacher leadership. Number 2, eligibility for the post of headmaster and superintendent of in a high school, high madrasa, as the case may be as follows. A. He must be a BA BCom with a BT BEd degree from recognized East University in respect of Hindi teacher having degree qualification. In Hindi, Parangat and Nisharat shall be considered instead of BT BEd. B. He must be at least 10 years of a teaching experience as a graduate teacher, provided that graduate teacher shall be included the cadre of assistant headmaster for the purpose of selection to the post of headmaster, and the seniority of the assistant headmaster shall be counted from the date of joining as graduate teacher with graduate scale of pay. Provided further that in case of amalgamated high school where ME, MB school has been amalgamated, the assistant headmaster is eligible for selection and headmaster subject to the condition that incumbent should have at least 15 years of teaching experience as graduate teacher, including the period of service in the erstwhile ME and MD school. 3. Roman 1. Before the end of the year, the inspector of school shall make an assessment of the number of vacancies to be occurred in the cadre of headmaster and the superintendent and to be filled up by promotion in the next year. The inspector of schools shall call particulars in the prescribed format of the eligible candidate research for filling up of vacancies for promotion. The member secretary shall hold the process of applications and submit them to the district selection committee. The district selection committee shall hold interview category wise and prepare a panel of a selection list, double the number of vacancies of the concerned district. Roman 4. The select list as so prepared by the district selection committee shall be submitted to the state selection board. The state selection board, after necessary verification as may be required, shall prepare a district-wise select list equal to the number of vacancies and publish the same in the office notice board or in such other places as the director may consider fit and proper. This is the rules of lordship.
This is a high school.
Lordship.
It's a high school.
Yes, lordship.
Now, the criteria is basically
Seniority law.
on basis of seniority
Yes,
and satisfactory and confidential report
Lordship.
the last 3 years.
Lordship. Lordship, the name of the petitioner, lordship.
So it's not entirely seniority, isn't it?
Yes, lordship.
Your ACR also has discounts.
So.
Lordship, the name of the petitioner appears in the Gazetted list, that is page 39, serial number 40, lordship. And the private respondent, lordship, all the private respondent, lordship, they are much value to the petitioner, lordship. And considering this all aspect of lordship, last week some of repetition have been disposed of, lordship.
You are at serial number 40.
40, lordship.
Quality of your annexure is not very good. See, it's difficult to read.
40, Khomna Binapani High School, qualification MA, B.Ed, UBC, lordship, date of joining 25/9/98, lordship, and date of receiving graduate scale of pay 25/9/98, lordship.
How many private respondents are there?
Lordship, 1, 2, 3, 4, 5, 6, 7, lordship.
7.
Lordship, page 14, I have lordship made a comparative, lordship, in my petition, lordship.
Page 49.
Yes, 14, 1/4, lordship.
14.
Para 11, lordship.
Private respondents have already been promoted.
Yes, lordship.
When?
Yes, lordship. Lordship, kindly see page 48, lordship, annexure 7. And this is the Baksha district, lordship, that is page 49, lordship.
No,
49.
Yes, lordship, 49, lordship. It starts from page 48, annexure 7.
Where are the names?
Lordship, serial number 19, lordship. Ranjit Vaishya. And lordship.
19 is petition respondent number.
Respondent number, Ranjit Vaishya, respondent number, lordship 6. And then the lordship. Kondorpa Huzuri, serial number 38, lordship. Respondent number 10, lordship.
This is only approval.
Lordship.
Where's the promotion order?
Lordship, this is the promotion per lordship order declared by the Director of Education, BTID, lordship.
This is only a proposal.
And one of lordship individual.
Mr. Counsel, what does the letter say? I am directed to convey the approval of the BTC for promotion. Is there no separate promotion order?
Lordship, based on this based on this proposal, Lordship, individual appointment order was issued by the director. Lordship.
When?
Lordship, one of the appointment order, Lordship, kindly see page 54, Lordship. And type copy is 53, Lordship.
Already
53.
issued.
Yes, Lordship. 53, annexure 8, Lordship. March 13 up to 24, Lordship.
They are made a party here, the promotees.
Lordship, a private respondent, they have
They are,
been.
they are a
Yes,
party.
Lordship. Yes, Lordship.
So will issue notice, let them file affidavit.
Lordship,
What?
Lordship, one order first by the
What kind of order is this?
Lordship, I have supplied it.
Yes, what does it say?
Lordship, kindly see page 22, Lordship.
Affidavit was filed in that case,
Yes, Lordship.
not in your case. In that case, affidavit filed.
Yes, Lordship.
That is why.
There
it
are
was
15, Lordship, 14 and 15, Lordship, it is observed.
Yes. Ms. Bora, what do you say?
Lordship,
What is your instruction?
as per my instruction, Lordship, Selection committee did not select him because of his SCR lordship,
Hmm?
because of his SCR,
This year,
annual confidential report.
it was bad. This year was not very good.
Yes, lordship, and lordship, as per rule also it is stated lordship, and select list is valid for only 1 year. He has come after 1 year. In rule 14, it has stated rule 14, 3, 6. The validity of the select list shall not exceed beyond 1 year.
What do you mean? He's in the select list?
Yes,
He's in the panel list?
Yes, yes.
Where's his name?
For headmaster. Where he is read lordship for
Where is-
14, rule
where's-
14, rule
where-
14,
Where is the panel list?
rule 14 kindly put.
Oh, Rule 14 we have read, we have seen it also.
Yes, yes.
You are saying that he's in the panel list and he has come after 1 year. What do you mean after 1 year?
His name was not there lordship because
Oh, his name is not there.
authority did not select him.
That's why he's come before the court.
Yes, lordship, let me file affidavit lordship.
No, affidavit you'll file, no problem.
Kindly fill my
See,
instruction law.
see, thing is that he says he's senior. Page number 14, there's a chart. All the 7 private respondents are placed below him,
Lordship,
starting from serial number 55 to ranging from 55 to 137.
only seniority is not the criteria.
I understand. So where is that ACR, which you say is not good?
Lordship,
ACR is for the year 3 years, isn't it?
I shall bring on record lordship. Let me file affidavit lordship.
Why do you say that he's come after 1 year?
Yes, lordship.
He cannot come after 1 year.
Lordship, but that promotion select list is for 1 year validity lordship. This para for rule 14, it has stated
Hmm.
rule 14, 3, 7, 6,
No.
3, 6. Rule 14, here lordship in book lordship.
It's abstracted in the book, in the writ petition,
Can
not required. Rule 14 what?
to select which one? Oh, program for progress. Approval list is March 12, 2024.
Hmm?
Approval list is 12 March 24.
And when was the writ petition filed?
The petition has been filed
Before that? I mean, before 1 year, 25th of February.
Yes, Lord.
How do you say that he's come after 1 year?
but as per my instruction, Lordship Selection Committee, the name of the petitioner in the case was not selected by the DPC, BTC on the ground that said selection was done on the basis of SCR service experience marks obtained in the interview score as his rating placed below than the respondent number 5, 6, 7, 8, 9, 10, and 11, who score highest marks in the aforesaid selection process of the promotion.
Okay, let her file the affidavit. We'll issue notice at this stage. Hart, Mr.
Yes, Ali. Yes, Ali.
S. Ali,
Lordship.
learned counsel for the petitioner, who submits that the petitioner is aggrieved with the promotion of the private respondent numbers five to 11 to the post of headmaster. Under the BTC. Despite being much junior to the petitioner. Of the learned counsel submits that the relevant of the Assam Secondary Education, open bracket, provincialized schools, close bracket, rules 2018 has not been followed by the respondent authorities in promoting the private respondents. Stop. A perusal of the said rule would go to show that seniority as well as the satisfactory annual confidential report for the last 3 consecutive years are the consideration for making such promotion to the post of headmaster. Stop. Next para. In view of above, issue notice of motion returnable by 3 weeks. Miss R.B. Bora, Learned Standing Council, BTC, accepts notice
3 and 4.
on behalf of respondents to number 2, 3, and 4.
And one.
Mr. S.M.T. Chisti, Learned Standing Council, Secondary Education, accepts notice on behalf of respondent numbers 1. Stop. Notice is therefore complete in respect of respondent numbers 1, 2, 3, and 4. Petitioner shall furnish requisite extra copies of the writ petition to the Learned Councils appearing today. To stop, petitioner shall take steps for service of notice upon the private respondents by registered post with ADD within 3 days. List the matter again on so and so. After 3 weeks, 22/7/2025. Stop. Since Miss R.B. Bora, Learned Standing Council, BTC, submits that she has received the instructions. Let counter affidavit be filed on or before the next date fixed. The affidavit to be filed shall also contain the manner in which the selection to the post of headmaster has been done by the respondent authorities. List accordingly.
This petition was initially filed with 2 prayers. Firstly, to grant our CCL, which is our statutory right given by notification, and secondly, to cancel the earlier grant of CCL leaves. Lordship, what has happened? Child care leave, Lordship. Child care leave. I wanted a leave from 21/1/2025 to 31/3/2025, which was granted on 12/3/2025. Page number 32, Lordship.
Page number 32.
Now it is given on 12/3. I wanted it from 21/1/2025 to 31/3. Now, if by a notification, I only get 730 days in my entire career.
21/1/25.
25 to 31/3/2025.
WPC King 2116. Lordship, in my petition, Lordship, in the index, Lordship, there is no annexure K. But he has Lordship annexure K. I have the last annexure that is given in my petition is annexure H in office copy.
No, I have already. I'm so sorry.
L is also there. And it's just K and L. You have only up till H.
Yes, Lordship. And pair is also different, Lordship, in my petition.
Lordship, I will serve it again.
Pair is different here. They have interim pair for stay. In my petition, there is no interim pair for stay.
I think there is some.
কি হল দেখুন এখন কি হ্যাঁ পার্টি নামটা একেটু বসুন্ধরা কামগন ডাইরেক্ট নহয় জানো
But this is not the first time it has been listed. Is it?
Yes. No, gone paishu. But to change the prayer, they have to amend the writ petition or they have to withdraw the earlier one.
No, change. Lordship, Lordship will take after some time, I'll just take.
Because in my petition, that prayer.
No,
the
if it
copy
is
served by
correct
the-
in court copy, then I can give a fresh copy to him.
No, in the court copy, there is an interim there.
Yes, but in my service copy, there is no such prayer.
What is your interim prayer?
Namely, we wanted a stay, Lordship, I am not pressing in that for the, I wanted a stay of 12/3/2025, 32.
An order that which he has already availed that leave. The order he want to stay lordship, that order, the benefit is the petition has already availed.
No,
The
Lord.
CCL leave is already she has availed that leave.
You should have got it typed out, this impugn order also. Not very legible.
Lordship, may I read it? Lordship, I am sorry. Ms. Bosundora Kankandari, assistant teacher of Silon Jati High School, hereby granted childcare leave of 70 days with effect from 21/2/2025 to 31/3/2025 as per government notification dated 16/9/2016. Now, Lordship, what has happened? I wanted leave from 21/1. They have sanctioned it on 12/3, Lordship, after 2 months. Now they have done it freshly, but this has to go. Now they have granted me the CCL, but this has to go because of the notification at page 34, which grants me only 730 days in my entire career. So if this remains, Lordship, from my quota 670 days, 60 days will go. Lordship would see page 33 for once.
But one thing is there, have you not availed of this leave already?
Avail, I have an instruction losses. I have the instruction.
Lordship,
And even
they have only granted leave from that instruction I have to take, but they have only granted leave from now on. Now, human instruction. From?
And even presently also
Now they have
availing
given.
the leave.
From April they have given. April to June. As per the fresh order 9/5, the leave is granted from 10/5 to 36.
That CCL leave 21/1 that she has already availed lordship. Now for 1 month of, after availing that leave till 31st of March, she remained absent from the school for a month of April. Then again on 8/5 she has applied, which was granted on 9/5/25 to 36/25. Now she is availing that second leave period lordship till 36. And for the month of April, she
By which order?
lordships order lordships that is there lordships.
By which order? I do not have the order. So Lordship, let them
See,
file affidavit.
Order dated 9/5/25 lordships and last annexure of this pages.
But you said you don't have a copy of this.
No, I have.
No, I don't have a copy, but that 9/5 order, Lordship would see.
9/5, this one, your instruction?
Instruction is the last page lordships. There's an order by the Inspector of School Lakhimpur 9/5/25, whereby the CCL childcare leave with effect from 10/5/25 to 36/25 has been allowed. And she's availing this lordships.
Yes, now it is, that's why I'm submitting, now it is given. But the earlier leave that was sought for from 21/1/25 to 31/3/2025. That was only approved on 12/3, Lordship.
No, Lordship. Earlier, those
Arre-
petition,
Okay,
we
but
have
in
to
a-
receive any application regarding the earlier.
It was approved later on, but the thing is that all those days you were availing that leave, isn't it?
Yes.
Lordship, that I have to.
You were not on duty.
No,
No, Lordship, that I have to take instruction. Lordship, they let them file affidavit, we'll reply accordingly.
So we'll have to issue notice then.
Yes, Lordship.
Start Mr.
Yes.
BP Board, Learned Counsel for the petitioner, who submits that the petition is agreed with the belated sanction of childcare leave for 70 days by imperial order dated 12/3/2025. Gustav, he submits that in view of the said order, the petitioner is bound to lose $70 days of childcare leave out of the total 730 days permissible during her service career. Next parent view of above issue notice of motion returnable by 3 weeks. Mr. S.M.T. Chisti, along with standing counsel, secondary education access notice on behalf of respondent numbers.
Lordship, respondent number 1, 3, 4.
1, 3, and 4.
Yes. 2 by my finances. But
Miss R.M. Bora. Learned Standing Counsel, Finance Department, access notice on behalf of respondent number 4. Not 4. Respondent number 2. Petitioner to serve notice to the remaining respondents by registered post with AD within 3 days. Extra copies of the petition will be furnished to the learned counsels if paid today. Counter affidavit be filed on or before the next date fixed.
Diplo.
Yes.
Please, Your Lordship. On last occasion, Lordship, the Council for the State Level Caste Scrutiny Committee has sought 3 weeks time for instructions, Lordship.
May I please, Your Lordship?
Yes.
Appearing for state level caste scrutiny committee, Your Lordship. Lordship, I have received instruction, Your Lordship. As per my instruction, she was directed to appear on 10th of June before the state level caste scrutiny committee for verification of her caste certificate, Your Lordship. On 29/5, she has appeared. She did not produce any document, Your Lordship. Thereafter, she was get opportunity again on 10th of June, Your Lordship. On 10th of June also, she could not produce the documents, Your Lordship. And she was given another 15 days time to produce relevant documents, Your Lordship, which will expire on 25th of June. May I place the instruction, Your Lordship?
What is the issue here?
The issue before Your Lordship is the petitioner Lordship, she got admission by way of an interim order passed by this honorable court, claiming that she belonged to other backward class.
Admission where?
In Jawahar Navodaya Vidyalaya, Lordship, in Karbi Anglong Difu, in class 6.
Class 6.
Class 6, Lordship.
Okay.
And thereafter, Lordship, in that particular, in petition number 3976/2023, that order was passed, interim order was passed, directing the respondents to provisionally admit. And the caste certificate which was produced by the petitioner, that was disputed by the Caste Scrutiny Committee, not Caste Scrutiny Committee, but disputed by the Deputy Commissioner, Kirby Anglong, saying that that caste certificate is not a valid caste certificate. That your Lordship will find.
How many petitioners are there?
Lordship.
How many petitioners?
Lordship, only one petitioner. There were several petitioners in 3976, the earlier batch of petitions. There were altogether 23 or 24 petitioners.
Yes.
And here the only one petitioner is before your Lordship, because now a show cause notice has been issued by the principal Jawahar Navodaya Vidyalaya stating that you produce a valid caste certificate, otherwise you will issue a leaving transfer certificate, or we will cancel your admission. And thereafter, Lordship will have to approach this honorable court, whereby this honorable court in this in writ petition number 1797 directed the Caste Scrutiny Committee to verify the caste status of the petitioner within a fixed period of time, within 30 days, and to submit a representation. And on 2/4/2025, we submitted the representation, and the Caste Scrutiny Committee, they did not take any action. And thereafter, again, we had to approach this honorable court by way of the present writ petition. And in the present writ petition, Lordship, these are the developments which my learned friend, has produced. Now, in my humble submission, Lordship, since the 15 days time is yet to be over, let the petitioner's father produce the relevant documents if he has, and thereafter the Caste Scrutiny Committee will pass a necessary order in terms of the judgment passed in Kumari Madhuri Patil, because a copy of the order, if they negate the claim of the petitioner that she does not belong to OBC, they will have to pass a speaking order, and that order has to be given to the petitioner.
So the first hearing was conducted on 10 June.
Lordship.
No, 29/5, Your Lordships.
No.
29/5.
SLSC.
29/5. Thereafter,
Thereafter 10 June and another.
10 June, then what is still left now?
She has still not been able to produce any document. Also, may I just submit one small thing? I'm appearing on behalf of the respondent number 2 and 4. My learned friend has not placed the correct facts before this honorable court, in the sense that in the earlier round of litigation, which was in 2023, by way of an interim order, she was allowed to study in the school. I'm appearing on behalf of the school authority, Your Lordships. Now, these are totally fully residential schools, Your Lordships, and the entire expenses of the child are being borne by the Jawahar Navodaya Vidyalayas, Your Lordships. Now, on the basis of the interim order, she has continued for more than 2 years to study from class 6 to class 8. And without producing the relevant certificate, in the judgment which my learned friend is relying upon, a time frame of 3 months is given in the judgment of Madhuri Patil, as well as what was given by this honorable court to produce the relevant documents before the authorities concerned. Now, the students in that petition, that batch of petition, were quite a number of students, and most of them produced their certificates. They appeared before the SLSC. They got their caste certificates verified, and those of them who cleared their relevant criteria, they have given us the OBC certificate or the SC certificate, and they have been duly granted proper admission under the authorities. Now, insofar as she is concerned, they were required to produce documents. On the last occasion, I had placed a bunch of documents before Your Lordships. It is perhaps there in the file, in the record. If Your Lordships may kindly just take up that particular bunch of documents, I would just place one thing for Your Lordship's consideration. That one, yes. Lordships, it is there. Page 3 of this bunch of document. This is a state level scrutiny committee which was held on 29th of December 2023 and 30th of December 2023. Now, page 3 of this particular document, you also will find on 29/12, some certain students have appeared. The names are there. And on 30th/12, again, some students have appeared. Now, on 30th/12, the petitioner has appeared at serial number 8, Sadhana Chaudhary. On 30/12. Your Lordships have got it?
Yes.
Yes. Now, on scrutiny, I'm reading the paragraph exactly below that. On scrutiny of documents submitted by the applicants, it was found that though all the petitioners claimed
that their forefathers worked in tea gardens, they were unable to furnish any document that could establish their link with the tea garden. They were therefore asked to submit documents corroborating their claim that their forefathers were actually employed in tea gardens within 15 days. However, time of submission was extended to 1 month on their request. Now, 30th of December 2023, 1 month would be 30th of January 2024. They have refused to appear before the authorities at all, before the SLSC, this petitioner. Thereafter, she continues to study with us. And when we issue a show cause notice to her on 30th of, I believe it is 30th of October 2024, saying that you have studied with us for 1 whole year and you have still not given us the certificate, it is then that she files the first writ petition before the Honorable Court, blaming the SLSC for not having sat to consider her case. Whereas the actual fact of the matter is that she herself has not appeared, and that is the categorical instructions on the earlier occasion placed by the SLSC. However, considering the fact that this Honorable Court gave a direction to the SLSC to sit again, now again an interim order has been passed in her favor. The fact remains, Your Lordship, that now we are going to be starting another new session. If the interim order continues, this child will have to be taken back again. And the fact remains that she may not be an OBC candidate and has yet studied with us for 2 years under the OBC category, which amounts to a fraud on this Honorable Court, amounts to a fraud on an OBC candidate, a genuine OBC candidate who might have been able to study for 2 years with the authorities, Your Lordships. My only submission before Your Lordships is that if Your Lordships are inclined to grant them time in the matter, the interim order may be vacated. In case in the month of July, when they are able to produce their report, if in case Your Lordships find that she is an OBC candidate, we will take her back. But if the interim order continues right now, then we will be bound to, because the session is starting from 20th of June. Our sessions go a little different, Your Lordships. We start in the month of June because they are fully residential schools. So on the 20th of June, perhaps the Honorable Court may not be able to take a call. Hence, my only respectful submission is that the interim order may not be continued at this stage. If she has a case and Your Lordships pass a direction, we will naturally be bound to take her back as a student. It is as simple as that. But if the interim order continues, then we'll be bound to take her on 20th of June, which would again create a lot of problems, and then another OBC child may be deprived of their legitimate due. That's my humble submission for Your Lordships.
Now, if Your Lordship peruses page number 17, as of now, there is an OBC certificate issued by the competent authority. Yet to be cancelled by the district commissioner. And in respect of the dispute regarding the caste of the petitioner, my learned senior friend cannot argue on that particular point because it is the district level, district commissioner, either the district commissioner or the state level caste scrutiny committee has to make the submission. That whether her certificate is fake, fraud, or whatever it is. Because as of now, at page 17 of the writ petition. And I'm very sorry to submit, Lordship, this is the second time an allegation has been made against me that I try to mislead this Honorable Court. And this is absolutely not.
The correct fact. That's all they're saying. I'm not saying you're misleading.
The interim order is no coercive action should be taken against the petitioner. That's all.
We were on summer vacation, Your Lordship. It was not a difficulty for us.
Yes.
However, the session starts
the interim order is paid
on 20th
by my learned senior, then it will be, her education will be at stake, Lordship.
And Lordship, 2 years, this child has not produced the actual relevant certificate. They have claimed a seat under the OBC category. What is the primary what is the primary criteria? If you're saying that you're an OBC certificate, candidate, what would be the primary criteria to produce an OBC certificate?
And therefore, the
OBC certificate, 2 years, this child has started with us. And she has yet to produce the most important.
That happened on the strength of some interim order.
Yes, Your Lordship.
Where's the interim order?
It is page 27. 27. He has annexed the. It starts at page 21. This was the first batch of writ petitions. She was there as well. Your Lordship,
now she's alone, isn't it? Now she's alone.
Now she's alone because the rest of the students, those who could produce the certificates, have been duly given admission. Those who could not have taken a transfer certificate and they're removed out of the school.
The earlier writ petition is 3976.
3976, Your Lordship, page 20.
What was the order?
4. So in this order, they were given 3 months time to go and appear before the SLSC, Your Worships, the state level caste scrutiny committee. You also will find that at page 53.
Start from page 51, paragraph number 37. There was a direction made to the petitioners to appear before the state level caste scrutiny committee with all the documents. In fact, at paragraph 37, there was a direction to the petitioners to apply before the district commissioner or the subdivisional officer of the concerned district for issuance of a caste certificate, which is in terms of the Madhuri Patel judgment.
Yes,
And
and have you done
thereafter,
that?
no, that is also there. Because
So they will not do their duty, and yet they want interim orders from this court. That is the strange part. The father of the petitioner has neither approached the deputy commissioner, nor has he gone and appeared before the state level scrutiny committee for a verification. And yet, by way of interim orders, they are being allowed to continue only because it is a child. I completely understand that this is the future of a child which is at stake. But at the stake of another child, another OBC candidate, another genuine OBC candidate.
there is nothing on.
So pursuant to this order,
Yes.
what happened?
Pursuant to this order, the state level committee sat in the month of December, which I have just produced those minutes before your lordships, that bunch of documents on 29th December and 30th of December. Now, page 3 of these documents, I just placed the minutes. On 30th of December, she appeared, and your lordships will find that they have noted, the state level committee has noted that we are giving them 1 month more time because they have been unable to produce any document. Therefore, we are giving them 1 month more time to produce their documents.
That 1 month ends on
The 30th of January 2024.
24. Okay, then.
Then she did not appear. She did not go back. She continued by way of the interim order. And the authorities also did not, perhaps thought that, the school authorities did not want to interrupt the session. Then she continued in the next session as well, your lordships.
Then what is this writ petition now?
Now she's saying that the SLSC, now they're blaming the SLSC.
May I place that particular fact, why this repetition has been filed?
Now,
at page 57, your lordship will find the show cause notice issued by the principal of JNB. Page 57 of my repetition.
no, start with page 56.
57 show cause notice.
56 show cause notice. 56 also show cause notice. That was a
This is the
reminder.
first show cause.
Yes, first show cause notice. So you'll have to start with there now. That in the month of October 2024, we issued a show cause to her, saying that you should please produce your OBC certificate. Nothing was done till the month of February 2025. Next page, page 57. Second show cause notice, that 5 months have again gone by and you have still not done anything. Please show us your OBC certificate. Or else we will be
Against that, lordship, we came before the court.
against that. Now they filed a petition,
At page
which is
60,
at
your
next
lordship
page.
will find that order.
Then you are saying that you have some representations pending?
Lordship, at page 60, your lordship may kindly bear us for him.
60.
Page 60.
Yes.
Para 4. In view of the submissions made by the counsel for the petitioner, there is nothing to be executed in this petition. However, in the event the petitioner submits a representation before the state level caste scrutiny committee on or before 4/4/2025, state level caste scrutiny committee should take a decision on the petitioner's representation expeditiously and not later than 30 days from the date of receipt of the representation. Para 5, petitioner shall also submit proof of having approached the state level caste scrutiny committee to the principal PM Sri School, Jawahar Navodaya Vidyalaya, Karbi Anglong on or before 4/4/2025. In the event proof of having approached the state level caste scrutiny committee is shown to the respondent number 4 on or before 4/4/2025, the respondent number 4 should not act upon the interim letter dated 28/2/2025 for a period of 1 month. So, in terms of this order, lordship, on 3/4/2025 at page 62, we submitted a representation. On 3/4. Though in the top of the page it says 2/4, lordship, but this was received on 3/4 prior to 4/4 because the direction was to submit a representation before 4/4, on or before 4/4. We submitted it on 3rd of April.
But where's the date?
Lordship,
Date says 2/4.
Lordship,
No, there's-
at bottom of the page, the seal, your Lordship will find the seal and.
Oh,
the
it was
date.
received on 3/4.
Yes. And then Lordship, no
Then-
decision was taken by the state level scrutiny committee within the stipulated 30 days period of time. And therefore, Lordship, this instant writ petition has been filed, seeking extension of time or with a direction to the principal not to terminate the petitioner, Lordship. And therefore, an interim order was passed in this writ petition, directing the state level scrutiny committee to take a decision on the representation filed on 3rd of April 2025, filed by the petitioner. And therefore, Lordship, the petitioner was called, the petitioner's father was called. He was asked to produce certain documents, and these documents, if your Lordship peruses the first batch of writ petition, the documents which is sought by the state level scrutiny committee, those documents relates to the grandfather of the petitioner or any of the family member who had worked in the tea garden of Assam. Now, the petitioner's father, who is a resident of Karbi Anglong district, he tried his best to procure his documents because he has to produce certified copy of those documents. He has to go to the tea gardens where his grandfather had worked, and therefore he has sought some time before the state level scrutiny committee. And therefore, the scrutiny committee has given 10 days time, which will probably expire on 25 of this month. So therefore, Lordship, now today, this case has come up before your Lordship. And now they are praying for
State level scrutiny committee.
scrutiny committee.
They are due to sit again on 26th.
Yes, Lordship, because they have already given time to the petitioner.
So again, she has appeared on 29/5, she could not produce. She again appeared on 10/6, she could not produce. And now as a final chance, I believe they've given her another 15 days, which my learned friend has just placed before your Lordships, those instructions.
29/6.
20, yes, perhaps it might be,
When is that?
Sudhila?
Lordship, the first letter is of 29/5 and second is of 13/6, your Lordship.
But where's that date?
Lordship, on 29/5, it is stated that on 10 June, they are requested to appear before the SLSC since they could not produce anything in 29/5, your Lordship. And thereafter, 10th of June also, they are unable to produce the required documents, your Lordship. Thereafter, another 15 days time has been allowed to them to.
So the time,
the required documents.
still time is there, Lordship.
Which will end on 25th of June, your Lordship.
25th of June.
Yes.
So we listed thereafter then.
Yes, Lordship.
So my only concern was about the interim order. That is my only concern because we will have to give her admission if the interim order continues. As per, because the session starts on 20th of June. Now they have taken time. He has merely taken time 1.5 years to come before this honorable court. What was he doing from January 2024 till February 2025, your Lordships? Where was he? 1 year and 1 month. He's blaming the SLSC for not sitting, whereas he himself did not appear. No, this thing before and the order which was obtained from this honorable court was at the first stage, motion stage, without issuing a notice to us or to them, without placing the entire facts, without placing the fact that they had not even appeared before the SLSC. That order has been taken by this honorable court.
Even we are not served with a copy of the writ petition, your Lordship.
It was at the motion stage. That is
Written
why.
in the order, your Lordship.
No, that was in the second batch of writ
And
petition.
firstly, the first time he has not appeared before the
Because
SLSC when-
the Department of Tribal Affairs was also made party.
In
It
the
is not
month
that the
of
interim
January
order was passed in
2024.
absence of the party. It
Lordship,
is absolutely a baseless
in
allegation.
the month of January 2024, when the applicant was called, when the petitioner was called to appear before the SLSC, she did not appear. The matter ends there, your Lordships. Thereafter, your Lordships will find I have just shown that the SLSC itself notes that we are giving you 1 month's time. She did not go back.
Lordship, a minor
Yes,
guard
it
is
is
before
gone.
your Lordship, seeking protection from the respondents. I leave it to your Lordship whether to continue with the interim order or not. But if your Lordship vacates this order, then she will suffer a lot. Because tomorrow they will not again give her admission. And if there is an assurance
Lordships,
by the
there is-
respondent side that
if
they will
she-
give her admission if the caste certificate
Of
comes
course,
in favor of the
that
petitioner.
goes without saying. If she is an OBC candidate, then naturally she gets
As of
admission with
now,
us.
there is a certificate.
No, that question certificate was challenged way back in the year 2023 when you came with the first writ petition.
Not a single
That-
affidavit in opposition
that-
was filed by the district commissioner stating that the caste certificate was issued by the
Lordships,
district
that
commissioner.
was the entire
It's
reason.
false.
That was the entire reason behind filing that batch of writ petitions, because of the fact that the authorities had raised a dispute with their OBC certificate. Till date, as I have mentioned, till date, they have only been able to continue on the basis of interim orders. Your Lordship may fix it up. I have no difficulty if Your Lordship fix it up immediately after the vacations. And the interim order may be modulated in such a manner that we will be bound to take her back if the SLSC says that she's an OBC candidate. We have no difficulty with that. But if she is not, and if we are allowed to continue her as a student, then would not another OBC student suffer, Your Lordships? Would that, and she has already taken this chance for the last 1.5 years, Your Lordships. More than that.
See, another thing is that supposing now interim order goes, and we say that subject to what?
Modified, Your Lordships. It may just be
No.
modified to the extent that we may not be, we are not pressurized to take her into admission just yet. It will be determined after the report of the SLS. If the SLSC decides that yes, she is an OBC candidate, we will naturally have to take her back, Your Lordships.
But what about the seat meant for that reserve category?
Lordship, because her seat is
Supposing it's already there.
because she's been continuing with us for 1.5 years on the basis of the interim order.
Now, if the admissions are now being done, if admission is not allowed,
It's already over, Your Lordship.
it's over.
It's already over. The session is going to start on the 30th. On
You've
the
got your
20th.
admission. You've got your admission.
She does not need to because she's already a student with us by way of interim orders.
So no
which are-
fresh admissions would be.
She
So
does
it's not a case of fresh admission, isn't it?
Yes, so there is no.
You were saying that there'll be a fresh admission. Because
another candidate may be, because the moment she goes away, another candidate might be accommodated in her place is my only mistake.
No, that cannot be
so
because.
if that is the
only-
case, now supposing ultimately she's able to produce that caste certificate or whatever, then what will happen? Somebody else are selected in the meantime.
Perhaps, Your Lordship, I do not know. But again, if there is an order from this court, we will naturally have to keep her over the and
So let it
excess,
remain.
over and excess the quota. My
Will-
my submission is that if one other child gets under the OBC category, then that was my humble submission.
I understand. See, the thing is that now if she has to go ultimately, then you take the other child, whoever's to come in again. And it's not a very long gap, isn't it? It is to be happen sometime in 26th, last date.
Last
Next
date is
date.
26. That's what. Yeah.
So we fix a date just after that.
So that
And
means
if
we are,
she's-
we are on vacation for.
If she's unable to satisfy the thing,
Then perhaps it could be taken up on the day of reopening, Your Lordships. And in the meanwhile, the SLSC will be directed to kindly submit the report before this honorable court without any further ado, because then that becomes a very difficult proposition for us, Your Lordships.
please write down. The parties are represented by the respective councils. Dispute raised. The issue involved in the instant case is with regard to the what do you call it? Caste certificate.
Caste certificate.
This regarding the
OBC certificate, Your Lordships. He claims to be an OBC candidate.
regarding the caste status of the petitioner who claims to be of the OBC category. Of the state level scrutiny committee that conducted hearing on 10th of June 2025. And thereafter has given 15 days more time to the petitioner to to produce the relevant documents in order to determine her caste. So the 15 days is to be counted from 10th of June 2025. So it is submitted at the bar that the petitioner has been continuing with our studies on the strength of the interim order passed by this court, and that further interim orders should not be continued. Stop. However, considering the fact that 15 days grace period has been granted to the petitioner to show that she belongs to the OBC category by the state level scrutiny committee, the matters deferred to be taken up. The matters deferred to be taken up again on you will have to come up after the vacation.
Immediately after the vacation. Your
Lordship. On 16th of July.
Lordship.
report to lawyer, what kind of what is that?
Who will produce the report?
My lord.
Caste level scrutiny committee.
Okay, Miss
Added.
R. Deka,
Also, what state level class between.
learned, is a government advocate.
Being council for social justice,
Okay, learned standing council,
state level class between committee.
learned standing council, social justice.
Yes.
Are they respondent here?
Number 7 and 8, I will declare.
Okay, R. Deka, learned council appearing for respondent numbers 7 and 8. Shall produce the report made by the state level scrutiny committee for perusal of this court on the next date. Registry to list accordingly. Interim order passed earlier shall continue till next date.
Bless you.
Yes.
Lordship, a copy of this instruction may be provided to the petitioner. The instruction which has been furnished.
Which instructions?
That the 10 days time has been granted to the.
It's basically a letter you can share.
Okay, I'll give you.
You give him a copy, it's only a communication, I think.
Yes, sir.
It's in the form of a letter only.
Should know that it's been granted 10 days.
Because this what the letter nowhere says that a copy of this letter was furnished to the petitioner directing him to.
It's in the report in the order today.
Lordship.
All right. Yes.
Please, your lordship. Matter relates to compassionate appointment lordship. Earlier instruction was called for lordship.
Yes, what is the instruction?
Yes, Lordship, in this case, I have received instruction, Lordship. Lordship, petitioner's father died, on the
30/12.
Lordship,
30/12/2008.
30/12/2008, Lordship.
Yes, so.
And he applied for compassionate appointment, Lordship, on Lordship, the application is 18/9/23, Lordship, after a gap of 14 years, Lordship.
Lordship,
What happened?
DLC recommended lordship.
Okay, only Lordship,
Page 30, Lordship.
Page 30, Lordship. It was only forwarded to the Lordship SLC, Lordship. Not recommended, not necessary action.
Lordship, page 30, serial number 3, Lord.
The date of government employee servant late Abdul Rahman was on 30/12/2008.
Yes.
And date of submission of application by Mustafizur Rahman is on 18/9/23. As there is a huge gap period for more than 15 years between the date of death of the government servant and submission of the application, the proposal may be forwarded to the government for necessary action. It is not recommended, Lordship. Only
Lordship, it was recommended, Lordship. Kindly peruse page 29, Lordship.
Yes.
Page 29, Lordship. Before table, last 2 line, Lordship. After threadbare discussion of the proposal for the appointment on compassionate ground, the meeting decided department-wise for selection of the candidate as follows. Here is selection, Lordship. That means recommended petitioner, recommended Lordship.
Remarks, Lordship, in the remarks, it was Lordship forwarded to the government. Lordship. So DLC has not taken any decision, Lordship.
Now, what about SLC? Have they taken a decision?
Now, pending,
SLC, that
matter is
instruction-
pending before the SLC, Lordship.
That instruction I don't have, Lordship.
What is your instruction? You please tell me. Otherwise, you're asking me to read all the pages.
Yes, Lordship. That's the same, same instruction from the DLC, Lordship. Same.
What is this instruction? This is the same thing which is written here.
DLC, I have received this.
Now, what I want to know is what did the state SLC do?
Yes, Lordship, the stand of the SLC, I don't have received any instruction, Lordship.
Hmm,
So Lordship, may Lordship, pray for some time, Lordship.
okay.
Lordship, as per minutes, Lordship, it was forwarded. Page 31, Lordship.
Hmm.
The
Yes.
down below, Lordship,
It is forwarded, Lordship.
it was
No, it's,
forwarded.
there's no dispute regarding forwarding of your
Yes, Lordship.
application,
Lordship.
but it is not a recommendation per se. It just says that it has been filed after a long time.
Yes,
They
Lordship.
could have rejected your application. Instead, they said, let SLC take a decision. Today, we want to know what the SLC has done. That's all.
Yes, Lordship.
After 2 weeks, Lordship.
All right, Miss
DD Burman, Lordship.
D.D. Burman.
Additional senior government advocate.
It's been a long time, Miss Burman.
After a long,
Miss D.D. Burman. Learned additional
senior government.
government advocate appearing for the respondents. Praise for and is granted further 2 weeks' time to obtain instructions with regard to the decision taken by the state level committee on the application submitted by the petitioner for compassionate appointment, which was forwarded by the DLC to the SLC on, what is the date?
DLC, that Lordship, 16/12/2023.
16/12.
2023.
No. I think the date is something else.
DLC, Lordship.
DLC, yes.
Yes, Lordship. In the page 29, Lordship.
16/12.
In page 29, first, Lordship. Minutes of the meeting, Lordship. Second line, Lordship. 16/12/2023.
What did I say? Last line? No, not 16. Date of forwarding is not 16/12.
4/1/24, Lordship.
Forwarded on 4/1/2024.
24. Yes, Lordship.
4/1 bracket next at 2. List the matter again after the ensuing summer vacation.
Obliged, Lordship.
Okay, we'll assemble that 2 again. Yes.
Kindly peruse page 32, Lord.
instruction.
Kindly peruse page 32,
Yes.
Lordship. On the basis of the complaint submitted by the petitioner, Lordship, the respondent number 2 issued a letter to the respondent number 3 and directed
him to take action in this matter, Lordship. But on the last occasion, instructions were thought for, Lordship.
Your Lordship, we're perusing to that, Your Lordship, last order dated, Your Lordship, where instruction has been shout for. We already communicated it, Your Lordship, but instruction is still awaited. So kindly grant us 2 weeks' time, Your Lordship, to furnish the instruction.
Or Lordship may dispose of the same by disposing the representation dated 23/4/2025, Lordship. That will suffice my case, Lordship.
Where is that?
It starts from page 34, Your Lordship. On basis of this, on the basis of the letter, this representation was submitted by the petitioner.
What is a grievance?
Lordship, what had happened, Lordship, the petitioner, when he was the president of the School Management Development Committee, and there were certain misconducts committed by the respondent number 4, Lordship, regarding which he had submitted several representation before the concerned authority. And on basis of one of the representation, Lordship, this letter was issued by the respondent number 2 to the respondent number 3. That is Annexure I, page 32, Lordship. But after this letter, Lordship, no steps have been taken, Lordship, regarding this which I have submitted this representation, Lordship, which is at page 34, Lordship. So my representation may be disposed of, Lordship. Because authority is to take up this matter, Lordship.
Let me furnish instruction first, Your Lordship. On the next date, Your Lordship, it may be disposed of perusing to that representation.
Lordship, kindly peruse the representation, Lordship.
Is this a representation?
Lordship, Annexure K, Lordship.
Is it a representation?
Lordship, with
Nothing-
regard to
Nothing has been elaborated, stated everything clearly.
with regard to the letter, Lordship, which is at page 32, Lordship. Issued by the respondent number 2 to the respondent number 3, Your Lordship. Can I go to the representation?
Please, sir.
What does it mean, this page 32? You want somebody to be transferred?
Lordship, transferred or to take necessary action, Lordship. I have submitted separate
Who-
representation, Lordship.
Whom do you want to be transferred?
Lordship, respondent number 4, Lordship.
You want respondent number 4 to be transferred?
Lordship.
Why?
Party bonai, sir. Respondent 4.
Why?
Lordship, there are several allegations against the respondent number 4, Lordship, on the basis of which this letter was issued, Lordship, that page number 32.
Respondent number 4 is the assistant headmaster.
Lordship.
You're the headmaster.
Lordship, I am the president of SMDC, Lordship.
Or you are the president of
Lordship.
SMDC,
Respondent number 4 is the
Management.
lady,
school management.
a resident of কি হয় কি মানে resident তাই কি হয় which post আছে
Take resident. Right,
but তুমি post to mention কৰিব লাগিছিল
ইয়াত আছে. Lordship, my simple is to do the needful in terms of that particular letter.
Your Lordship, let me obtain instruction, Your Lordship. And here, Your Lordship, a private respondent, Your Lordship, she is also have to appear. Because
Please,
direct allegation is against this respondent number 4. So her appearance is necessary here.
See, the president of the SMDC
Lordship.
has recommended, has sought for transfer of the assistant headmaster. And he has written to the inspector of schools.
No, Lordship. This letter is from Director of Secondary Education to the Inspector of Schools, Lordship.
Okay, director.
Director, Lordship.
And director has got the information from whom?
Lordship, Director has got the information with regard to a petition submitted by the petitioner, Lordship.
On
It is at page
which
32, Lordship.
32.
32, Lordship. Regarding petition dated 8/11.
Oh, 32 is a letter from the director himself.
Lordship.
So,
So petition is at Lordship,
where is the petitioner's letter?
page 30, Lordship.
30.
Lordship. An extra is.
Some complaint has been given to the minister.
Lordship. Thereafter, this letter
Then-
was issued.
This letter was issued by the director to the inspector.
Inspector
schools.
of Schools, Lordship.
Then what has he done?
Nothing, he has done nothing, Lordship. Thereafter, I have submitted this representation, Lordship,
34.
which is an annexer K, page number 34. So my simple prayer is that to do the needful in terms of the letter that's going through. That must, Lordship.
Only one
Nothing
date
more than
has
that.
been given, Your Lordship. This is the very second date, Your Lordship.
Will you
Let me
kindly post the
obtain,
representation, Lordship.
let me obtain instruction first, Your Lordship.
To do the needful, that must, Lordship.
I'm trying to understand the case. Okay. Giving time and all that, we'll see. Where is this 811? Oh, 811 is the letter.
11,
to
Lordship.
the-
That must, Lordship.
Transfer this again. SMDC, this is the main authority.
The case is before the respondent number 3, Your Lordship.
Inspector,
Yes, Lordship.
let her get the instructions.
Lordship.
How much time?
Lordship, 2 weeks time may be given, Your Lordship.
On the request of Miss
PDAS,
P. Das.
appearing for 1, 2, and 3 secondary education.
Your standing counsel,
Yes, Your Lordship.
the standing counsel, secondary education, for the 2 weeks time is to grant it to obtain instructions as to
PDF eta diba, huh?
what steps the inspector of schools has taken. Pursuant to the letter dated
7/1/2025.
7/1/2025 of the Director of Secondary Education. As well as the letter of the petitioner himself dated 23/4/2025. List again after the ensuing summer vacation.
Lordship. Oblige, Your Lordship.
Deeply obliged.
Yes.
May I please, as your lordship? My lord, the matter relates to, my lord, non-payment of salary to the petitioners. My lord, what has happened, my lord? The petitioners were initially appointed from the year 1991 till 1999 on various dates, my lord. We have mentioned in a specific paragraph as an, my lord, assistant teachers in, my lord, middle English schools in Nagaon district, my lord, at that relevant period of time. My lord, admittedly, at the time of our appointment, my lord, the schools were not provincialized. Subsequently, my lord, though schools were provincialized, we were left out, and that had been compensated by the government by way of regularizing us in the, my lord, various categories of posts, which were substantive and vacant at that relevant period of time, my lord. Now, my lord, may be pleased to find our regularization orders I have annexed at page 32, my lord. My lord, from page number 32 to till 37 is the various regularization orders, my lord, issued time to time by the, my lord, District Elementary Education Officer of Nagaon, Assam.
How many petitions are there?
My lord, 6 numbers of petitioners are here, my lord. Now, my lord, what has happened? And these similarly situated teachers, my lord, who were appointed in the similar mode and manner, my lord, were also not paid salary, my lord. That's why time to time, my lord, various writ petitions were filed before my lordships and before this honorable court also, my lord. One of such petition, my lord, may be pleased to find we have annexed at page 50, annexure 4, my lord, wherein, my lord, a specific direction had been issued. My lord, may kindly turn to page 54, my lord.
Yes.
My lord, may I be permitted to read over a small paragraph, my lord?
Yes.
After hearing the learned counsel for the parties and noticing that the issue pertains to non-payment of salary of the petitioners, these courts deems it fit and proper to dispose of this petition in the same line as in the judgment and order passed in a batch of writ petitions. The lead case being WPC number so-and-so Sudhendu Mohan Talukdar versus the state of Assam disposed of by this court on so-and-so, ordered accordingly. The petitioners would take necessary steps for getting their cases referred to the committee mentioned in the said judgment and order number so-and-so. My lord, what has happened in that Sudhendra Mohan cases, my lord, judgment, the government was also required to constitute a committee, my lord, to verify the veracity and authenticity of our existence as well as the nature of appointment by which we were made, that whether our salary can be considered or not. Accordingly, my lord, basing on that, my lord, our cases has also been processed and an inquiry had also been conducted, my lord. That inquiry report I have annexed, my lord, is at page 57, my lord. I am not troubling my lordships with the, my lord, with the relevant first 2 pages, but the paragraph, page 59, my lord, is the field verification report of the following middle school teachers under Nagaon district had been mentioned, wherein my lordships may be pleased to find the name of the present petitioners, my lord, that serial number I have mentioned, and the result and the status had been shown as working, my lord. My lord may kindly note the date. It is a, admittedly, this report is of, my lord, 2013, my lord. 21/11/2013. So, my lord, what has happened? After this report, I have annexed the entire report, my lord, in the next page chronologically, though it is not illegible very much, my lord. So, I have made typed copy of the relevant part for the bring into the kind notice of my lordships with the relevant part, my lord, in respect of the petitioners, my lord. Now, my lordship may be pleased to find, basing on this report as well as the subsequent development, a writ petition had been preferred before this honorable court, my lord, in the year 2013 itself, wherein, my lord, altogether, my lord, for Morrigaon district, similarly situated persons had approached before this honorable court, my lord, by WPC number 268 of 2013, wherein this honorable court, by way of an order dated 3/3/2017, my lord, dispose of the said writ petition. I would straight away take my lordships to the page 74, my lord. The paragraph 14 is the operative part, my lord. May I read, my lord? Para 14. Having held thus, a direction is issued to the respondent authorities to take steps for payment of arrear salary to the petitioners in terms of the case in Harendranath so-and-so, and having regard to the date on which so-and-so was instituted. Steps for payment of salary be completed within a period of 4 months from today. Needless to say, the respondent shall make payment of the current salary to the petitioners without any interruption. Writ petition stands allowed to the extent above, no costs. Now, my lord, the present petitioners, my lord, are also, my lord, similarly situated to this batch of petitioners, my lord. If my lordship goes through the entire judgment, it reveals, my lord. Now, my lord, what has happened? Admittedly, my lord, this petition was disposed of in the year 2017. Thereafter, my lord, though the petitioners are expecting, with a legitimate expectation, my lord, that they as they are also being similarly situated, my lord, their cases may consider, my lord. But as this same is not happening till date, my lord, therefore they prepared a representation. My lord may be pleased to find that representation is at page 75, annexure 9, my lord. This is a representation made of late, my lord, on 23/8/2024. My lord, with a prayer that our salary should be paid, and this representation had been, my lord, dispatched by of a registered post, my lord, and we have also, my lord, annexed the track consignment report, my lord, which explicitly shows that, my lord, item had been delivered on 24/8/2024 before the concerned respondent, my lord. But till date, this representation has not yet been disposed of, my lord. So, my lord, my humble and very limited prayer before my lordship is that, my lord, by considering the entire aspects of the matter, the respondent authorities may take up my representation, my lord, and can dispose of the same by way of a reason order, my lord, by considering the entire facts and circumstances as well as the various, my lord, precedents passed by this honorable court, my lord.
Well, at this stage,
Instruction.
I will be allowed to take instruction on the next day. Otherwise, notice may be issued.
Sorry?
Pending notice may be issued. In the meantime, I will take instruction.
Please write hard Mr. A.R. Bungal, now counsel for the petitioners, who submit that by filing this petition, the petitioners are seeking for a direction to the respondent authorities concerned to release their area salaries and other allowances from the date of their respective joining in their schools. First of the learned counsel submits that the case of the petitioners is squarely covered by the
The order dated
3/3/2017 passed by this court in WPC number 268 of 2013. So the learned counsel further submits that the petitioner had submitted a representation for the Director of Elementary Education, Assam, on 23/8/2024. But since the same has not been considered or disposed of, the petitioner having no alternative is before this court. Next, in view of above, issue notice of motion, planned by 4 weeks. Miss
And Fukan,
N. Fukan, Lawrence Standing Council,
elementary.
Elementary Education Department accepts notice on behalf of respondent numbers
1, 3, 4, 5, 6, and 7.
1, 3, 4, 5, 6, and 7. Who else is there?
Coming to any,
Miss
RM Barwan.
R.M. Barwa. Planet Standing Council Finance Department accepts notice on behalf of respondent numbers 2 and 8. Petitioners to serve requisite copies of the petition to the Lawyer Council's appearing today for the respondents. This is the matter again after the 4 weeks. Pendency of the writ petition shall not be a bar for the respondent authority concerned to dispose of the representation filed by the petitioners on 23/8/2024.
Obliged, highly obliged.
My pleasure, Lordship.
Yes.
My lord, the case relates to a notice whereby they are asking for excess drawal of salary, which was, according to them, that it was made at the initial stage of 1989. but they have given the notice after my retirement, that is I retired in the year 2023. They have given in the year 24. So, my lord, similar nature of case, many cases of this honorable court, with in consideration of the Supreme Court judgment Rafiq Masi, case were disposed of, and in the manner this honorable court, my lord, asked them to verify, and being a grade 3 employee, and if it is made beyond after 5 years of that initial mistake, then you should not go for any recovery. And if they find that it was wrong, then make the corrected statement and regularize the pensionary benefits. So this case is, my lord, over here. A bunch of cases were. So in this line, the issue being no longer res judicata, res integra, my lord, this case can be disposed of, my lord. My lord, there were 5 cases. My lord, would your lordship be pleased to see the page 4, paragraph 4, my lord.
Yes, please read.
My lord, the common grievance of the petitioners is that though they have retired from service, they have not been paid their pensionary and retirement benefits on the ground of wrong fixation of pay scale from the initial entry in service as teachers in their respective schools. Next. Over here, there were 5 petitions, so it is in plural, my lord. 5. Learned counsel for the petitioner submit that these petitions can be disposed of in view of the law laid down in the state of Punjab and others versus Rafiq Masi, whitewasher, and others, reported in 2015 4 SCC 334. Learned counsel further submits that in such cases where there has been wrong fixation of pay, and if the concerned employee is not involved or has not played any role, there should not be recovery of any excess amount paid on account of wrong fixation of pay scale. The learned counsel appearing for the state also submits to the same effect. 6. Accordingly, this court is of the view that these petitions can be disposed of with a direction to the respondent authorities to examine as to whether any of the petitioners were involved directly with the wrong fixation of the pay scale as alleged by the authorities. If upon such verification it is found that the petitioners did not have any direct role to play in the said erroneous fixation of pay, the question of recovery will not arise, as they cannot be made to suffer after retirement because of certain error made by the concerned authorities in fixing the pay scale. 7. Accordingly, these petitions are disposed of with a direction to the respondent authorities, more particularly Elementary Education Department. It is same department here, my lord, to make such verification. And if it is found that the petitioners were not involved in any way directly for the said wrong fixation, there cannot be any recovery from the alleged excess amount already drawn by the petitioners. The pension, however, will be determined. The pension, however, will be determined on the basis of the correct pay scale which the petitioners are supposed to get as per rule, and accordingly, the authorities shall release the pensionary and retirement benefits of the petitioners on the basis of such correct pay scale attached to the post of the petitioners. In this regard, the finance department will do the needful and pass appropriate order for waiver of such excess amount already drawn by the petitioners in this regard upon receipt of such report from the education department. The aforesaid exercise shall be undertaken within a period of 3 years, within a period of 3 months from the date of receipt of the certified copy of the order. In my case, my lord, exactly covered, but only thing is that they were giving me the provisionary pension, my lord, provisional pension. Because of that, my lord, wrong fixation committed by them when I was initially given that in the year 1989, when I was an assistant teacher, obviously I didn't have anything to do with it. But they stopped my provisional pension from June 2024, my lord. And because of that, I am suffering, my lord, acute financial hardships now. So taking the paragraph 5 particularly 5, 6, and 7, my lord, this case can be disposed of, my lord, in the same line. It is exactly same case, my lord.
Yes.
Yes, my lord, I have gone through the judgment, my lord. My lord may dispose of the similar on 14.
In terms of this order?
Yes, I have gone through.
Please write down. Heard Mr. J. Abedin, learned counsel for the petitioner. One petitioner, isn't it? Only one.
Only one.
And Mr. G.
G.
Pegu,
Yes.
learned standing counsel,
Elementary education, my lord.
elementary education department.
Respondent number 1, 3, and 5, my lord.
Appearing for respondent numbers 1, 3, and 5.
Yes.
Stop. Having regard to the nature of grievance projected by the petitioner,
My lord, I think finance is respondent number 2.
the writ petition is taken up for disposal at
and
this
5.
stage. You add one more, Miss R.M. Bora, is it? R.M. Barwa. Miss R.M. Barwa, also had Mr. Miss R.M. Barwa
There is.
for respondent number
2 and 6.
2 and 6.
And state will be, my lord, for 4.
Video.
And Mr. V. Diori, learned junior government advocate for respondent number 6.
4.
Sorry, respondent number 4. Okay, then the next line is that having regard to so and so at this stage. Then next para, it is the case of the petitioner that he was initially appointed as stipendiary teacher by order dated 13/3/1985 and thereafter received regular scale of pay with effect from 7/4/1988. Stop. He retired from service on 31/1/2023. But after his retirement, the respondent number 5 served him a notice on 4/7/2024, alleging that the petitioner had excessively drawn his salary and therefore asked the petitioner to refund the excess drawal of rupees 4,21,930. To stop. The petitioner therefore filed his representations on 5/6/2025 before the respondent number 5. But same has not been considered. And his provisional pension having been stopped since June 2024. The petition is before this court. Top next para. Mr. J. Abedin, learned counsel for the petitioner, submits that since the petitioner did not have any role in the wrong fixation of his pay, any excess withdrawal that may have resulted. May not be demanded from the petitioner. In view of the settled law in the case of State of Punjab and others versus Rafiq Basi, reported in 2015, 4 SCC 334. Staff the Learned Council submits that a case of similar nature had been disposed of by this court
Yes.
White order dated 37/2019. Before order, you write white common order dated also. And the writ petitions being WPC number 322 of 2019 and WPC number 163 of 2019. Next para, having regard to the issue involved, the writ petition is therefore disposed of with a direction to the respondent authorities more particularly to the Elementary Education Department to make such verification with regard to the excess withdrawal of salary by the petitioner. And if it is found that the petitioner was not involved in any way directly for the said wrong fixation, there cannot be any recovery from him for the excess withdrawal of salary. Full stop. However, the pension of the petitioner will be determined on the basis of correct pay scale which the petitioner is supposed to get as per the rules. I think that should do.
Well, that finance department's part, your lordship, need to mention, because they are the one who is to waive.
To stop, it is needless. It is needless to state herein that the finance department will do the needful and pass appropriate orders for waiver of the excess withdrawal of pay by the petitioner upon receipt of a report by the education department. So the entire exercise be conducted and completed within a period of 3 months from the date of receipt of a certified copy of this order. Writ petition stands disposed of accordingly.
My lord, only thing is that your lordship may pass an order that in the meantime I should get my, as the order has been already passed, there will be no excess. So my lord, from June they have stored my provisional pension. So I should survive, my lord. June 2024. So my provisional pension should be carried out, given my lord.
Your provisional pension was calculated on what? Okay.
It is not actual regular pension.
It's a lump sum only.
Yeah, it is a lump sum.
Till such decision is taken, it is provided that the respondents shall
continue to
pay the provisional pension to the petitioner, which was said to have been discontinued since
June 2024.
The month of June 2024. All right.
Deeply obliged.
Get to your office. By this application, the petitioner has paid for grant of rupees 10 lakhs from out of his salaries, which has not been paid to him since 2018. He's a teacher, my lord, in the lower primary school at Bajali district. And presently, he was undergoing treatment for renal displacements and other things, my lord. And now, Government of West Bengal has granted permission in the medical department for replacement of the kidney. Unless he has sufficient money, my lord, that order I have given already in record, my lord, by which the Director of Medical Education, West Bengal government has given the permission for kidney replacement. In Fortune, my lord. Yes.
Yes, why is it listed today?
On the last occasion, my lord, the government told an order by which the payment of salary was stayed in an earlier case. But in the same case also, there is another subsequent order of 12/11/24 by which respondents were directed to pay his salary. And since nothing has been paid, my lord, it has become difficult to undergo the operation. So at least by this application, I have paid for grant of rupees 10 lakhs, my lord, which is the minimum of his 2 years salary, because presently minimum salary of a teacher would be not less than 50, and presently he would have drawn more than 80,000. And calculating this, my lord, it will be less than 2 years of salary for the petitioner. So I'll humbly submit that this amount be allowed to be paid to the petitioner, my lord, within a very short period, so that he can undergo the operation, my lord.
Your monthly salary has been withheld.
He has not been paid salary till
Since 2018.
2018.
How is that?
There was a case, my lord. It is 4024 of 21. I think that record is very objective. I see. In that, my lord,
Yes.
your lordship will see by order dated 12/11/24, the Honorable Court directed the government respondents to pay the salary to the petitioner. Comply with your direction passed by the Honorable Court remand, failing which suo motu contempt proceedings against the erring respondents shall be drawn. The petitioner submits that despite these orders passed by this court, the petitioner is yet to be paid salary till then. So, without going into this, my lord, if an lump sum amount of rupees 10 lakhs is ordered to be paid by the Lord, my lord, he will be able to undergo the operation, my lord, to save his life.
My lord, in this matter, Miss S. Sutia, my learned friend has been looking after my. Kindly fix up the day after tomorrow. My lord.
Why?
She has some personal difficulties. She has not.
No. What is there, my lord? It is a simple case. There are earlier orders that it should be. I don't think why they are delaying the matter, my lord. They want the person to die.
That's it. Miss, last occasion, my lord, kindly see the last order.
Yes.
She has
Last
produced
occasion,
some-
court gave time.
She has produced some instruction. There is some anomalies in instruction.
On the last occasion, the order of the court in the earlier case, my lord, dated 19/5/2023 was shown.
Where's that order? 1953.
19/5. In the
Where is that order, Mr. Chalian?
copy is
1953.
there, my lord. In 4024, my lord.
No, that file is not here. File is not here.
No, copies are there, my lord. Copy was there, my lord. It was shown last time.
No, it's not here. That's why I'm asking you.
Now you can see this. Question petition.
How many writ petitions have been filed?
Earlier there was one. In that case, this order was passed. Your lordship will see the earlier order passed by the Honorable Court in my petition on the last occasion on.
You've given me this 4024.
4024, yes. That order is of 9/5/2023.
Yes, correct. So out here, there's a stay.
That was stay.
Stay of release area salary of the petition.
Yes, 12/11/24. There was another order in that case, Milord.
Where's that order?
I've given a seat, Milord. And your lordship see the earlier order passed by the Honorable Court,
It is
Milord,
not
in my
available.
case.
There's only one order. Nine. Yes.
No, আমার কিছু order. আমার কিছু ছুটি আছে। Your lordship may see the 11th order of the court, Milord, in this my case.
In which case?
In this present case.
Order dated?
11/6, Milord.
11/6, yes.
In 3023. Only for that reason, Milord, the court gave them time. Otherwise, court was about to pass the order. 11/6 order, Milord, of the court.
Yes, it says Ms. S. Chutia, Learned Standing Council Elementary Education, has however submitted that certain instructions have been received, which would show that there are certain anomalies. Considering the urgency involved, matter stands adjourned. So what is that anomaly?
Nothing is recorded, Milord. They're only delaying the matter.
Miss Shruti is not there today.
Yes.
What to do?
Her sign is not well. Her sign is not well, so she's. So, my lord, can we fix up the paper tomorrow, my lord?
Mr. Chalia, we'll have it on Wednesday. Let her come. We'll see what she says.
Paper tomorrow. আমাকে একো নকলেও এটা অর্ডারটো চাই গম পাইছে।
The other case which you just said, is it still pending?
Yes, Milord.
Any other further order passed in that case?
Yes, Milord. On 12/11/24, Milord.
What was the order? 12/11. Twelve 11.
There also question of payment was discussed, Milord.
Where is that previous order? The previous order which had the same case.
Same case, Milord. Same case.
4024.
4024.
Then 9/5/23, the payment was stopped.
Yes.
On
For some
9/5.
clarification.
On 9/5/23, payment was stopped. Again on 12/11. It relates to some case, some order passed on 24/9/2021.
That was the initial order
Oh.
admitting that case, my lord, 4024, where direction was given to the state, my lord, to pay, release his salary.
That direction was there, but then again, it was stayed, isn't it?
That is true, my lord.
It was stayed again thereafter. When was it? When was that?
Then again, on 12/11, my lord,
Hmm. So time was taken for instructions. Then on 7/4, another order. List after 4 weeks.
thereafter, my lord, no specific order has been passed in the case
This writ petition 4024 is filed for what purpose?
for salary.
Then the present one, 3025?
For release of that amount for the treatment, my lord.
I see.
Since the salary is not paid,
Hmm.
it is pending. Nothing has been done. Petitioner had no other option, my lord. Because he has to go for this. Government has already given him permission. He is in hospital, my lord, admitted.
Why area salary, isn't it? Why salary was stopped, by the way?
There was some dispute regarding his joining. Although there were joining reports and that reports were transferred forwarded to the senior authorities, my lord, that was not taken cognizance of. His salary was not paid. Then
Transfer on mutual consent.
yes, my lord. And I have stated in my petition, my lord, in the present petition, on 23 October, the director called me along with the junior officers in the district and personally heard me about this matter. And they said, he said personally that everything will be settled after 1 month. But that was also not done. Petitioner had no other option, my lord, but to pray for this.
So what salaries which you're entitled to as on today is lesser than 10 lakhs, is more than 10 lakhs?
More than 10 lakhs. My lord, now the salary of a teacher, my lord, as I am told, it is more than 80,000 per month.
And salary is not given to you since when? 2018. Which month? 18?
July, I think.
Transfer, after being transferred.
2718, he transferred, joined. 2718. That I have given the next D, my lord, page 18.
All right, Mr. Chalia, we'll list it on Wednesday and let the other matter also be listed together with this 4024. We'll see what can be done. Although
If something is done, my lord.
Although Mr. D.P. Chalihal, Lanet Senior Counsel, assisted by Ms. M. Roy, is present. Ms. S. Sutia, Lanet Standing Counsel, Elementary Education Department, who is appearing on behalf of the department in the present case, is absent. Let the matter be listed again on 18th of June 2020, along with WPC number 4024 of 2021. Please inform Ms. Surya that we'll take up on that day and let us get instructions. All right.
All right.
Yes.
The petitioner was granted permission to start higher secondary, that is 11 and 12, by the government in 2005, by the council, the Higher Education, Assam State Education Council.
My lord, at the preliminary, my lord, I want to point out one thing, my lord. The petition is not properly filed. Lordship kindly see, cause title, my lord. Here, address is made to the, my lord, Chief Justice. Honorable Justice Vijay Bishnoi, Chief Justice. At the filing of the petition, Lordship Chief Justice was not there. Lordship was elaborated to the Supreme Court. Now he has filed his petition 2nd of June. How that can be, my lord? Because it is up to your lordship, my lord. I am not prejudiced. My lord, lordship can take it up or not, my lord. If it is made it like that, my lord, it will be at tantamount to disrespect to the acting Chief Justice. As per High Court rules, it is not as per High Court rules.
No, I can't get into a quarrel with that, my lord. It's absolutely your lordship's discretion. I am also not sure. If it needs to be corrected, it has to be corrected, my lord.
Get it corrected?
I'll do that.
When?
Otherwise, at the oral request, we'll do the needful if your lordship.
Well, my duty is to point out, my lord.
That I agree.
My duty is to point out, my lord, whether it is properly filed or not.
We'll get it corrected in the records if on our oral request. If your lordship grants the permission, we'll correct the
I think
record.
orally will be difficult, I think.
Right.
Nowadays, I think application is required.
Right.
We make a small application, we allow that and you
required.
replace the page.
Yes, yes, required.
We can replace the page.
No, for that, IA, you file an IA.
Now system is IA. To any amendment of the cause title, my lord, IA has to be filed.
Online, I got file it.
Online, I'm told was, my lord, I don't want to get into that, my lord.
Lordship may take this matter after some time. We'll just make sure, Lordship, because we need some urgent
Not
orders.
today,
also.
sometimes, my lord.
So some students are waiting for admission, therefore it is urgent also, therefore.
No, when you filed it.
Lordship, I'll just
He
confirm.
wants to verify, my lord. Apparently, there was
Students are waiting. Students are waiting. Somebody is waiting. That means he used filed an improper application before lordship to get an
I'll just
order.
confirm.
If it is lordship allowed, then it is up to the lordship.
We list it on Wednesday again.
Yes, my lord.
Meanwhile, you just see what he can do.
If lordship can take after some time, I'll just.
No, sometime. I will not be there.
After some time, after one matter, I'll just confirm when it was electronically filed, Lordship.
DS did a notification, my lord.
When it is electronically filed, I'll just check the date. Because on the date of e-filing, it may be.
No, I don't want to get your lordship on this issue into such a, your lordship may have it on Friday. They would know when it was electronic.
The affidavit filed on 2nd of June, 25.
You take up, we'll have it on Wednesday. Wednesday.
Or will it be next Monday, my lord?
Monday, all right?
Next.
This is the matter again on 12/3. Let's speak with them in Monday. Senior counsel. You file one small
Yes,
application.
my
we give
lord, that is the correct. Deeply obliged.
Obliged.
Yes, yes.
Also, the petitioner before your lordship, she worked as a lordship graduate teacher arts in GB Sokhani High Secondary School with effect from 15 to 2014 to 26 to 2014. That is for a total length of 10 years, 11 days service. Thereafter, lordship, in terms of an advertisement, lordship, she was appointed as a PGT Political Science in Tinsukia Bengali Girls High Secondary School on 21 to 2014. And she joined service on 27 to 2024. Now, lordship, my grievance in the present writ petition is that, lordship, although I have completed 10 years of service, the gratuity amount has not been released to me. Per Section 4 of the Gratuity Act, lordship, continuous service period of 5 years qualifying service is required. I have completed 10 years, 11 days.
No,
Neither Lordship pay protection has been given.
You have retired.
No, Lordship, I am working as a PGT, political science.
Then how you say that you have to pay paid gratuity?
No, from my previous service.
Previous
Initially,
service.
Yes, yes. I was initially appointed as an arts graduate teacher in GB Shokhani High Secondary School.
Okay.
And I worked there from 15 to 2014 to 26 to 2024. That is for 10 years, 11 days service. Thereafter, Lordship, in terms of the advertisement, Lordship, I have been appointed as a PGT political science in Tinsukia Bengali Girls High Secondary School. Neither I have been given, Lordship, the gratuity amount and leave encashment. Neither I have been given, Lordship, the pay protection from my previous service. That is why, Lordship, my salary has been degraded.
So previously you were working under Dishan.
Under the same respondent, Lordship, the Director of Secondary Education, Assam.
No. The name of the institution.
GB
Chokhani.
GB Shokhani.
BC Chokhani.
GB Shokhani.
GB.
Lordship. Gopal, Lordship.
GB.
Gopal
Chokhani.
Krishna Girls High.
Then now you are working under?
Under Lordship Tinsukia Bengali Girls High Secondary School.
So you are taking the gratuity for the service rendered in the
Lordship, in my previous school.
GB Chokhani.
Lordship.
Okay.
Now, if they have treated me as a press appointee, they should release my gratuity because they have not even given me pay protection for my previous service.
You are treated as a fresh appointee.
Press appointee, Lordship.
What do you say?
Your Lordship, pertaining to that, Your Lordship, notice me go, Your Lordship, notice me issue.
All right.
Because he had mentioned that anomaly in merit list. So, Your Lordship, pertaining to that, notice may go at this stage.
No, that issue has been over. I've already been appointed.
Let's issue notice at this stage.
Yes, Your Lordship.
Heard Mr.
SK Das.
SK Das, Learned Counsel for the petitioner, who submits that the grievance of the petitioner is that he has not been released her gratuity for the services rendered in Ganga Bishan Chokhani High Secondary School with effect from 15 to 2014 to 26 to 2024. In terms of Section 4 of the Gratuities Act 1972. Mr. The Learned Counsel submits that the petitioner is now working in Tinsukia Bengali Girls High Secondary School. And the respondent authorities have not treated her previous service has not treated the present service as a continuity from the previous service rendered by her in GB Chokhani High Secondary School. To stop, therefore, they should be directed to release the gratuity amount due to the petitioner. Stop. Next, in view of issue notice of motion returnable by 4 weeks. This will be the
Extra copy will serve upon us.
Yes, I will, sir.
Standing Council Secondary Education Department. Accept notice on behalf of all the respondents.
Soft copy. PDF.
I'm just listening.
No, you don't appear for finance also, isn't it?
No, Your Lordship, for finance,
finance.
he is there.
Okay. Appears for respondent number?
Finance, what?
No, see.
I am appearing for 1, 2, and 5.
1, 2,
Secondary
and 5.
education.
While Ms. R.M. Bora, Standing Council Finance Department, appears for respondent numbers Respondent number 4. Petitioner to serve requested extra copies of the petition to the learned counsels appearing today. This again after 4 weeks.
I'm deeply obliged.
If your lordship can give an observation, lordship, that pendency may not be a bar to dispose of my pending representation. Lordship, if in the meanwhile, lordship, they
Where is your representation?
representation, lordship, at page. Yes. Page 63.
Next line. '63.
Lordship, page 63.
Pendency of the writ petition shall not be a bar for the respondents to consider and dispose of the representation of the petitioner said to have been filed on 21/9/2024 before the Director, Secondary Education.
What's up?
Deeply obliged.
May please, Your Honor. I
Yes.
beg to, I beg to mention this item. Let the matter be fixed for Friday, Your Lordship.
Friday.
For Friday.
Okay, let's again on Friday. Give the date, huh? Friday. As paid for by the council for the petition.
65, no? I'm preparing for secondary education here. Pertaining to item number 64.
You'll come up on Friday again.
Yes, sir.
Eight is lawsuit. This matter relates to recovery after retirement, my lord. The petitioner for lordship, my lord, he retired on 31/10/2023 as teacher. After his retirement, my lord, in the name of finalization of his pension, some amount was recovered from him. And that amount lordship will find that has been recovered at page 62. Page 62, my lord. That amount has been refunded the authorities.
Yes.
2,32,651 rupees. And thereafter, my lord,
How much is the amount?
2,32,651, my lord.
This has been recovered.
My lord.
What is this excess drawal of salary?
In the name of excess drawal, my lord. And my lord, also will find page 65. This is the amount, my lord, this year's the amount was sanctioned. Here also, my lord, in column Z, they say that overpay allowance, 2,32,651. This was directed to be recovered from the petitioner. And though it was recovered earlier.
Page 65.
Page 65, my lord.
Where is that column?
Column Z, my lord.
Column G.
Paragraph 2, my lord, column Z. Overpay allowance. 2,32,651.
Okay.
This amount has been, my lord, refunded by the petitioners. But after retirement, my lord, perhaps, my lord, it is not permissible in way of, my lord, traffic mercy.
Was the same amount?
Yes, yes, my lord. This is the amount, my lord.
I thought it was a different amount. You are showing the same amount.
Same amount. Same amount. It has been recovered.
What is the reason for with recovery?
They say that, my lord, some increments were added to the salary of the petitioner by the authority by making wrong calculation. As per their, my lord, calculation.
Amount is already recovered.
Already recovered.
When did you retire?
On, my lord, 31/10/2023.
And recovery was made on?
Recovery was made on, my lord, that is 6/6/2024. One more aspect is there, my lord. The pension has been finalized, my lord, on the basis of, my lord, a wrong, my lord, last pay drawn amount. Last pay drawn amount, Lord will find the headmaster of the principal of the school, my lord, he issued the last pay drawn certificate at page 59. That amount is, my lord, 58,700. Serial number 2, my lord, at page 59.
Yes, no,
But instead of 58,700, my lord, my pension has been calculated on the basis of, my lord, 56,990.
where's the figure?
That figure also you will find.
Fifty-nine
At
is your
page
LPC.
71, page 71.
59 is your LPC.
Page 71 also you will find. On the basis of 56,990, my pension has been calculated.
71.
Page 71, my lord. No, my lord, at this-
56.
Yes, my lord. At this stage, my lord, possible pass an interim order, my lord, directing the authority to refund back the, my lord, recovered amount. And my lord, on the issue of, my lord, the calculation of the pension, possibly issue notice, my lord. My,
So why should we direct at this stage to refund?
Yes, my lord.
Let notice go.
Notice may be over.
well, as the recovery is not permissible.
We'll see about that. See,
Yes,
at this stage, it's not that they're going to withdraw. Had it been, they're going to deduct, it would have been different, but they have already deducted.
Yes, yes.
So let us see what,
That has been
what,
done already.
heard Mr. Ayed Saikia, learned counsel for the petitioner, who submits that the petition is aggrieved with the action of the respondent authority concerned in recovering a sum of rupees 2,32,651 from him after he retired, after he already retired from service on 31/10/2023. So the learned counsel also submits that pension of the petitioner has also been wrongly fixed by taking into account by not taking into account the last pay drawn by him before he demitted office. Next, para in view of above, issue notice of motion returnable by 4 weeks. Mr.
U Sharma,
U.
for
Sharma.
respondent number 1, 2, and 3, my lord.
U. Sharma, standing counsel,
Yes, for secondary education department.
secondary, standing counsel, secondary education department, except notice on behalf of respondent numbers
1, 2, and 3, my lord.
1, 2, and 3.
On behalf of Bishop.
And Mr. D. Das. Mr. D. Das, learned counsel, accepts notice on behalf of
B. Sharma, respondent number
B. Sharma, respondent number 6.
D. Sharma, is it?
B.
On behalf of Mr. B. Sharma, who represents respondent number 6.
B. Sharma 6.
Finance.
This 1 to 3.
Finance. Or board.
There was a lady here. So I am Baru or somebody.
Sir, A. Salia will, so,
Who?
A. Salia.
Has he come today?
Yes,
Mr.
he has come, absolutely. Yes.
Mr. A. Chaliha, learned standing counsel, finance department.
Yes, come.
Accepts notice on behalf of respondent numbers 5 and 8.
5 and 8. 5 and 8.
Anyone left?
My lord, 4,
Pensions, director of pension.
4 and 7.
Director of pension.
Well, 5, 7, and 8, my friend will.
Oh, 5, 7, 8. 5, 7, 8. Who's the standing counsel for pension? Mr. B. Devi, learned junior government advocate, accepts notice on behalf of respondent number 4. So, since the parties are represented, no formal notice is required. However, the petitioners shall serve requisite extra copies of the written petition to the learned counsels appearing today. List the matter again after 4 weeks.
Lordship, our names may be reflected in the cause list. Lordship, our names are not
Reflecting the names of the learned,
finance department.
reflecting SC Finance, comma, who else?
Yeah, something.
G Assam. Okay, reflecting the names of the
Respective council.
respective parties in the cost list.
Fix a date after petition, madam.
4 weeks.
Let me fix, madam, if possible, madam.
List again on 28/7.
Oblige, madam.
May I please, Your Lordship?
Yes.
My lord, the applicant before your lordship with a prayer for vacating the interim order, by which order the provincialization of the petitioner was suspended.
You are the writ petitioner.
I am the respondent, private respondent, and writ petitioner's service was not provincialized. Whereas the present applicant's service is provincialized as tutor. And after provincialization, the applicant joined in the school. Accordingly, till today, he is servicing. And my lord, after provincialization, lapse of about 8 months, the writ petitioner approached before this honorable court challenging the appointment of the petitioner, present applicant. By order dated, my lord, 8/11/2021.
Page number?
Page number 16, my lord.
16.
16.
That is the interim order.
Yes. By this order, the salary of the petitioner was not released. Order is passed on 2021 and applicant's salary stopped last February, my lord, in 25. That is why subsequently approached before this honorable court for vacating that interim order.
Salary not paid to you.
Salary, government paid the applicant. And it was continued till February 2025. Subsequently stopped.
Stop from which date?
My lord.
Stop from which date?
Last, my lord, February salary is paid, subsequently not paid.
You are not getting pay from which date? From which month?
I am getting salary from the month of February 2021, my lord.
Up till?
Till February 2021.
Same date, what do you mean then?
My lord, sorry, my lord. It is, my lord, salary received from, my lord, 9th of February 2021 and till February 2025.
So since from March 25, you're not getting.
My lord.
What is the interim order passed?
My lord, that is page 16, my lord.
Further effect of provincialization be not given to respondent number 6.
Yes,
This
ma'am.
one. And respondent number 7 also.
Respondent number 7 also.
You are for both?
I am for respondent number 6.
6 only.
My lord.
7 has not filed anything.
Not filed this for vacating, and he filed
also the
What is the
Counter-
status, what is the status of the writ petition?
read petition, my lord, it is admission stage,
Admission stage.
my lord.
The pleadings have been
Pleadings
exchanged?
are exchanged,
Exchanged.
my lord. I have
So-
also, I have filed the
Lordship,
Counter affidavit.
government also has not filed affidavit. And as well as my lord. this,
You are for
I am for the writ petitioner.
writ petitioner.
And my lord, the petition filed by respondent number 6, my lord, Sheikh Hanibuddin.
Hmm.
Lordship, kindly have a look at the page 30 in my petition. He is my lord far junior to me. And therefore, this honorable court passed the
That will
interim.
see who's junior, who's senior.
My
we'll
lord,
see.
the
Now,
page 30, my lord, kindly have a look, my lord, his position.
no. What I'm trying to say, please listen. Rightly or wrongly, you've got some interim order in your favor. And that was not implemented for a long time.
my lord.
And only in March, from March onwards, they stopped giving him salary,
My lord.
which prompted him to file the vacating application, stay vacating application. Now, my question was, if the writ petition itself is ready, why not go for that? But I find that the state respondents have not filed.
Yes, Lordship.
You are appearing. Why you have not filed affidavit till now?
Yet to receive our instruction.
Huh?
Yet to receive our instruction.
When will you receive? It's the case of 2021.
2021.
Have you submitted any objection to the IA?
Where is the lordship may dispose of petition directing the petitioner to approach the appellate authority under section 14.
Why didn't you say that in the year 2021? After a matter is pending for 4 years, then now you come up with that fine idea that tell him to go to that place, not here. What to do?
That is there, my lord. My lord. Regarding my lord, statutory provision, writ petition is not maintainable. As because the tribunal is there. Without approaching tribunal and without approaching first the authority and subsequently tribunal, district tribunal, directly approach this honorable court, my lord.
What is that tribunal?
Tribunal, my lord, as per Act 17,
Same book. Is it same book?
yes, my lord, same book.
Page number?
Page number, my lord,
24.
222, my lord. Appellate authority 222 and the tribunal that is 124, my lord. Section 19.
124.
124. Section 19. Suit and proceedings.
Please read.
Section 19. Suit and proceedings. Clause 1. No suit, prosecution, or other legal proceedings shall lie for anything in good faith done under this act, except with the previous sanction of the state government. Clause 2. To adjudicate disputes for redressal of grievances relating to teaching staff of the non-government educational institution as well as disputes concerning disciplinary action, genuineness of establishment of school and a claim for provincialization. That's provincialization, my lord. In respect of teaching staff of Bhansar educational institution, there shall be an educational tribunal for each district within their respective territorial jurisdiction. The district and session judges, and the additional district and sessions judges of each district are designated as educational tribunal.
So this pertains to which district?
My lord, it is Bobra district, my lord. Borpeta, my lord.
Borpeta.
My lord.
Now, how is the proceedings to be drawn in under this tribunal?
My lord, each and every district after enactment of this act, each and every district, the tribunal established under the jurisdiction of district and sessions. When any proceeding filed under this act, the district and session judge played as a member of the tribunal.
That though we have seen. I'm asking you, how do they go about it?
In Borbara district, how it is run, well, but I have conducted a case in Morigao district. That is in as civil suit, like civil suit. Like civil suit, taking evidences.
Okay.
And after taking evidences, finally declared judgment.
So what is to be done in this case?
My lord, here, my lord, case
In
is-
this case, my lord, that is the case, my lord, they have to approach before the tribunal.
But here, my lord, I challenge the provincialization order because, my lord, one junior already been provincialized and senior already been deprived. So this is the approved court, and accordingly, this court passed the interim order. Because kindly have a look, my lord, page 16. As per, my lord, section 3, subsection 1, close page 17, my lord. The interim
Page
order.
17 of?
17 of the IA, my lord. It's clearly mentioned the section, under which section this provincialization order passed. So against this order, my lord, this is a writ maintainable.
17 years.
Yes, in the middle portion, my lord, under section 3, subsection 1, clause 11 of the Assam Education Provincialization of Service of Teachers and Reorganization of Educational Institution Act 2017, in short, Act of 2017, as language, social science, and science and mathematics teachers, respectively. 2 further teachers were provincialized from the same school, apparently, by invoking the provision to section 3, subsection 1, clause 11. The 2 further teachers who were provincialized are respondent number 6, Sheikh Hanifuddin, which is before your lordship by filing the IA, and the respondent number 7, Sunaruddin Ahmed Sunaruddin, was appointed on 1/3/2010, and Sheikh Hanifuddin was appointed on 20/1/2006, whereas the petitioner number 1, Muhammad Baharul Islam, was appointed on 10/1/1988, and the petition number 2, Muhammad Nur Abdin Mandal, was appointed on 28/3/1993 in the NC Customary ME Madrasa, as the 2 additional teachers were not provincialized against any specific subject, and the 2 petitioners being senior between the 2 teachers who were provincialized, a prima facie case has been made out. Because the document, my lord, the teaching staff has not been challenged in the IA. So far, in the writ petition page 30 is concerned. This prima facie case, they are far junior. How they can claim to be appointed? Therefore, the Honorable Court rightly passed this interim order. They cannot have any legitimate right to claim. Junior one, how can approach with the court? Record itself reveals they are far junior. They cannot jump. And now they're claiming by filing IA that this interim order is wrong. The interim cannot be taken into account as wrong. Right order passed. And the Article 226, my lord, clause 3 is not a mandatory, my lord. This is a discretion of the court. So, my lord, let them file, my government file the affidavit and matter will be disposed of. The petition. Because it is pending since 2021. We are being deprived, being a senior, my lord.
My lord, regarding maintainability, this honorable court also passed order whereby the writ petition was dismissed for on the ground of statutory maintainability.
You know, it is against the even provincialization order. Provincialization order cannot survive because junior one has been provincialized. This is quite different situation.
After your lordship granted me, then I will file our affidavit. My lord.
Yes, my lord. We are suffering, my lord.
And not only this, my lord, they approached this court after leaving the school.
No.
They left the school in
How?
2021 in the month of March.
No.
And approached this honorable court in the month of October.
Without pleading, my lord.
Yes, this is, there is pleading, my lord.
Without pleading.
In my IS, that pleading is
Where?
there, my lord.
Where are you?
Yes, that is there. And on that count, my lord, I have annexed the teacher attendance also.
Lordship. Short date may be given for that.
Although the learned counsel for the applicant has sought to impress the court that the interim order should be vacated. But this court is of the view that instead of considering the application, the writ petition itself should be taken up for final disposal. However, since the state respondents have not filed their counter affidavit, they are granted 2 weeks' time to file their counter affidavit. Let the matter be listed on 16th of July 2025.
My lord, 18th of July. 18th. 1/8.
Friday.
My lord. Friday, today Monday.
18th of July is Friday.
Yes, my lord.
I don't know.
Or if it is final hearing, then my lord.
Let come on Tuesday then,
Tuesday.
22nd. Let the matter be listed on 22nd of July for admission hearing.
Lordship.
Obliged. In between, my lord, government authority may file their.
Yes, I've given them 2 weeks' time, but it's more than 2 weeks. No one appears for the petitioner when the matter is called. Same was the case when the matter was listed on 5/5/2025. So it appears that the petitioner is no longer interested to pursue the matter. Stop accordingly. The matter stands dismissed for non-prosecution.
I'm appearing for secondary education.
Okay, Miss
PDAS.
P. Das, learned standing counsel, secondary education appears for the department.
Deeply obliged.
May I appeal? As per last order 28/5/2025, my friend Mr. will be supposed to.
Well,
go to
here
the
we have
inspector.
already sanctioned now. As area wages now.
Regarding payment of area wages,
My lord,
what is the status today?
we have already sanctioned my lord. He will receive my lord.
Sanction?
It is under process, my lord.
When was it sanctioned?
Next phase, my lord. Next phase, my lord.
Now, when will the payment be done? What is the process?
Process, my lord, it will be deposited in his account, my lord. Process is on, my lord, as per the communication, my lord. No. Yes. Steps of payment. Yes, it is.
Yeah, Mr. Bora, isn't it?
My lord, PK Bora.
Mr. PK Bora, Learned Counsel for the respondent number 4.
My lord.
Submits that the financial sanction for payment of arrear wages to the petitioner amounting to rupees 3,08,700 has been made on 13/6/2025, and therefore the amount will be debited into the account of the petitioner
This was probably.
within a short time, considering the submission made.
So Lordship has some technique, it is under process, so we cannot be at that time of say this may be deposit in his bank account. So
Sorry?
next week, Lordship, this I take instruction.
Next week.
Next week. Next Monday. Or next Friday.
What do you say?
Well, others, we have already sanctioned, my lord, it will be deposited in his account, my lord, it is under process, my lord. As per my communication, it is reflect, well, under process.
Can we not close it?
More thing, because but last occasion they have sanctioned it, but there is some is a wrong heads. They have amount is not deposit his account.
After 2 weeks, then, my lord.
Hmm?
After 2 weeks, in the meantime, he may receive the amount.
No, if you have given the sanction, then
Well,
what is
true,
it, what remains?
Yes, it's required by my friend, my lord.
Last occasion, they have sanctioned, but due to the wrong heads, the amount is not deposited in my account. It is on their record. Lordship may see.
But otherwise, as per communication, it has clearly reflected that the amount has already been sanctioned. Now.
So we'll listen next week then, next week. In view of above, list the matter again on 25th of June, 2025. You have a spare copy of this?
Yes, I have, I'll provide him.
This will remain in the record.
My lord.
Copy of the financial sanction dated 13/6/2025 produced by Mr. PK Bora, Learned Standing Counsel, Elementary Education Department, shall be kept on record and marked as extra information.
Obliged, ma'am.
This is a review petition seeking review of your lordship's order 27/9/22. It is essentially on the ground that your lordships by that order had directed the inspector of schools of the jurisdictional institute run the school, be the in-charge principal, because there was contesting between two rival parties. The law is as it appears, as your lordships have also held, even for in-charge appointments, the educational qualifications are to be met, that your lordships have held. So that relied upon judgment related to an additional deputy commissioner. Here the educational requirement is BA, MA, plus B.Ed, plus B.Ed. B.Ed, these officials don't have. This is a teaching qualification. The executive branch normally don't have, and that is, so review was sought on that ground, my lords, that the jurisdictional inspector of school does not have the necessary qualifications to hold the post. Now, there was some issue regarding whether the post was also sanctioned or not. The post actually, in your lordship's order, it was recorded the post was not sanctioned. Between the education department and the finance department, the files were moving. We are now 3 years down the line. I don't think they have still to take a definite decision to sanction the post. And the jurisdictional inspector of school, lacking the educational qualification, continues to hold the post. That is how, my lords, the matters are. I am the senior most qualified with educational qualification and the senior most person. The order, the last order of the government was in my favor in the writ petition. There is a lot of history in this matter. The first, because at one point of time, though I was senior, I didn't have the B.Ed qualification. Therefore, the writ petitioners had been initially, that grant was granted in charge at some point of time. Subsequently, that order came to be stayed, and I was made in charge. The writ petitioners filed where the court granted interim relief to the writ petitioners. Then the application for modification was filed where the order seeking review was passed by your lordship. That order your lordship will have, your lordship's order is at page 13.
Temporary refill on the submission made by the council, then post will be created. It was not brought to the notice.
Your lordship, having looked at the rival contention and disputes, thought it would be proper for the jurisdictional inspector of school to hold that post. And your lordships, at page 15, the council was recording that within 1 week will grant sanction, but now 3 years have gone by. And at the penultimate paragraph at 15, upon considering the submissions made by the parties and also taking into account the materials available on record, the court is of the considered view that the interim order dated so and so requires to be modified. Accordingly, the Director of Education, BTC Kokrachar, is directed to issue appropriate order directing the inspector of school under whose jurisdiction the school is situated to act as the in-charge principal of the school concerned within a period of 15 days from the date of receipt of the certified copy. The judgment which I seek to rely and which lays down the laws that the educational qualifications are also required to be met even in appointment, in-charge appointment, that your lordships will find at 124. This was a case when the in-charge was entrusted to the additional deputy commissioner, that your lordship will find at 126, somewhere in the middle. If your lordship sees the relevant provision of the communication dated 4/4/22, my lord has that, that's 126. Yes. So in this case, the additional deputy commissioner was given the in-charge position until appointment of a permanent principal. And then in paragraph 5 onwards, the law is laid down, if your lordship sees, at 127. My lord has paragraph 5.
5.
Minus 127.
Yes.
As per law, an incumbent who is duly qualified and eligible alone can be allowed to be principal of an educational qualification. Further, as laid down by this court in so-and-so, reported in so-and-so, it has been held that even in order to be an in-charge principal of an educational institution, the incumbent concerned must satisfy the educational qualifications and other eligibility as may be prescribed for the post of principal. Accordingly, it is the contention that even in order to be in-charge principal of government section Mahavidyalaya, Nagaon, the person concerned who is made in-charge principal would have to satisfy the required educational qualification that are prescribed for the post of principal in the state institution. Mr. So-and-so Learned Counsel for the Elementary Education takes a stand that allowing the additional Deputy Commissioner Education, Nagaon, to be in-charge principal is a temporary measure which will remain effective till a permanent principal is appointed, and therefore the respondents are within their competence to allow the additional Deputy Commissioner Education to be the in-charge principal of the school. As we can skip 7, minus 8. Essentially, a deputy commissioner is a concept which flows from the Assam Land Revenue Regulation 1886 and further is also entrusted with certain other duties and responsibilities pertaining to the district administration. The deputy commissioner under certain statutory provisions also discharges the duties of deputy collector and under the Code of Criminal Procedure discharges the duties of district magistrate. In any view of the matter, the duties and responsibilities of a deputy commissioner is circumscribed by the aforesaid provisions of law as well as per the other duties and responsibilities entrusted upon the deputy commissioner by the government of Assam as required under various provisions. The service conditions of faculty members of government section Mahavidyalaya Nagaon is governed by the National Council for Teacher Education Recognition Norms and Procedure Regulation 2014. Rule 5.2a therefore provides for qualification for the post of principal of an institution governing the regulation, and there, my lords, it is culled out. And if your lordship sees paragraph 5, this is the education, but paragraph 14, if your lordship sees, or paragraph 12, my lord. In view of the aforesaid proposition of law, in the instant case, we have to arrive at a qualification that even for the purpose of being in-charge principal of a school, the incumbent who is allowed to be the in-charge principal must necessarily have the required educational qualification and eligibility as prescribed under the regulation 2014 for being principal of the institution concerned. And if your lordships comes to paragraph 14, in the circumstances, we put a query to the Learned Counsel for the Educational Department as to whether the additional deputy commissioner who is allowed to be in charge principal of the government section Mahavidyalaya as per communication dated so-and-so does have the necessary educational qualification prescribed under 5.2a of the regulation. The forthright answer is that the concerned person does not have the requisite qualification. We have taken note of one of the required qualification is MEd with minimum 55 marks, which in fact the deputy commissioner does not have. From such point of view, the conclusion that can be arrived at is that the additional deputy commissioner who's made the in-charge principal as per communication does not have the necessary qualification and eligibility to be the principal of the government section Mahavidyalaya, and consequently does not have the eligibility to be the principal, in-charge principal, and they set it aside. So the law is, my lords, even when your lordship is considering for in-charge position of any post, the requisite educational qualification has to be satisfied. In this case, my lord, the requisite qualification under the relevant rules are Rule 12, my lords, and that your lordships will find at page 118. This is pre-amendment, but this has remained as it is. And if your lordship sees 12.2, the minimum qualifications for appointment to the post of principal in higher secondary school or higher secondary and multi-purpose school shall be as follows. The candidate must be a MA, MSc, MCom with BT, B.Ed degree from a recognized university having uniform good academic career. Usually, my lords, people in the administration, because B.Ed and B.Ed are essentially, my lord, teaching qualification. This was, my lord, the amended 2017. I think your lordship will get that. The same provision is there at 120, 12.3. Now, this is one aspect of the matter, but the matter has been adjourned from time to time because your lordships were desirous that they should take steps to sanction and have a regular post of principal. That is also not forthcoming for the last 3 years. And your lordship, in the first order of the review also, we had moved the review after a lapse of 1 year. So somehow the government is not taking any steps to create a sanctioned regular post of principal. We are in a situation where last 3 years, the in-charge jurisdictional inspector of school, not having the requisite educational qualification, is holding the post. I am the senior most assistant teacher with the requisite qualification. That seniority list your lordship will find at page 103.
Serial number 1.
My lord, I am serial number with B.Ed, MA. At one point of time, I acquired this B.Ed only in 2018. So at that point of time, in 2017, Bhaskar Das was given in charge. But today, as it stands, I am the senior most with the requisite qualification of MA and B.Ed. In the order which is impugned in the last of the writ petition, your lordship will find that it is at page 70. Therefore, the government also took a decision to grant in-charge position to me, that is 20th June 2021. This is how, my lords, the matter stands, my lords. Initially, by the order dated 6/8/21, an interim order was passed in favor of the writ petitioners, Bhaskar Das, my lord. That then came your lordship's order, which is under review, thought to be challenged.
Initially, an interim order was passed in favor.
In favor of, my lords, the writ petitioner. I am a respondent number 5 here. That your lordship will find at page 76A. The operative part is at para 7 at 76D. In the circumstances, we direct that this petition now be listed with so-and-so. There are two. In the meantime, as the present petitioner is in charge was not correct because prior to the order in my favor, there was an order in favor of another person by the name of Mr. Kakoti, which was impugned by me. But he was in charge from 2017 till 2020. For a long period of time when I didn't have that. In 2017, when the first order was passed in his favor, I didn't have that B.Ed degree, but I acquired in 2018. Then comes, my lord, this order was modified by your lordships at page 13.
Who's for the other side?
Lordship,
Go
I'm
ahead.
referring for the BTC for school education, Lordship.
What is
Lordship,
happening
my
now?
learned colleague D. Mushahari was supposed to appear in this matter, but she has fallen sick and she has left the court, Your Lordship. So
Who?
D. Mushahari, Your Lordship.
Di Mushad.
Yes, Your Lordship.
For which, for whom, which,
For
for
the
which respondent?
secondary department, Your Lordship.
Any idea what is the steps taken at this stage
No, Your Lordship.
regarding the sanction of post and all that?
No, Your Lordship, I didn't have any idea regarding this, Your Lordship.
My lords, I leave it to your lordships. Lordship can have it on 23rd with that other matter. If your
That
lordship.
is Monday.
My lord, or whenever convenient to my lords.
We can do that. We have on Monday.
Yes, Your Lordship.
You get, ask him to get the instructions, whatever.
Lordship may indicate that in that order so that they convey to your lordship, but other, if they are not taking steps, then the senior most qualified person should be in charge.
We'll simply put it on Monday.
As your lordship so pleases.
What's his name?
D. Mushahari, Your Lordship.
Mr. D. Mushari, learned counsel.
Yes, D. Mushahari.
Miss that.
D. Mushari, learned counsel, who appears for the
Secondary department.
secondary education department. It's not available today when the matter is called up. And therefore, let the matter be listed again on 23rd.
Answering that.
Deeply obliged, ma'am.
Obliged, Lordship.
Very well. So trying to manage how, I don't know, feeling busy.
Yeah.
Anyway.
Unless here instruction is within my lord 2 weeks time may be granted here. my lord.
What instruction? Some more time?
Lordship, earlier date was take time for instruction.
What is the order? Which is the order not complied with?
Lordship, page number 14, para 11 and 12.
14.
Lordship, 13, page number 13.
Operative portion.
Para number 11 and 12.
Release of area salary.
Weeks may be granted. So
Then
that-
what will happen after 2 weeks?
To get the present status of the case, my lord.
You are appearing for which respondent?
Sole respondent is there, my lord.
Sorry?
Sole respondent is there.
Sole respondent.
Yes, ma'am.
Okay, as paid for by the learned counsel. Mr.
You, Sharma.
U. Sharma, appearing for the sole respondent. List the matter again. 2 weeks means it's going to go after the vacation.
Immediately after vacation, my lord.
List the matter again on 16th of July. All right. Let's continue.
44 and 45.
Yes, sir. Well, kindly see last pair of my communication, madam. Subsequently, the consolidated report has been forwarded to the Finance Budget Department for their views and further examination, and appropriate action will be taken upon receipt of the response from the Finance Department.
Yes, some process is happening.
Going on. If they come after vacation in that event, my lord, let them update thereafter. A date may be given, my lord.
The U Sharma.
And
U Sharma.
PK Bora, man.
Sorry, PK Bora, sorry. Mr. PK Bora, Lanet counsel declaring for the
Respondent number 3. man.
respondent number 3 seeks for and is granted for the 3 weeks time to come up with up-to-date instructions. Since it appears that some process is on. In terms of the letter dated 13/6/2025 produced by him. List the matter again on so-and-so. 23/7.
Bless.
Where is your document? The last order, the content matter, my lord. The last order may be seen by last order.
Well, in the meantime, if review petition are filed and it was been detected, then some technical defects, my lord, that we have said to correct it, my lord. What is the technical defect is that review petition is not accompanied by IA for condemnation. There is no requirement of IA. That's already, that is the reason that registry had not listed this case, my lord.
There is nothing more delay tactics, my lord, to implement the order, my lord.
If we do review petition file, my lord, that it was not listed, my lord. She will grant me 10 days time. I will convince them to list that case, my lord. Because only because of their IA is not been for condemnation delay, there is no requirement of filing condemnation of delay in a review petition, my lord. There are settled position law, my lord.
Which case is that? Item number?
Item number 47. This is
contempt.
Contempt, my lord.
The contempt.
47. Against that order, review petition has been filed. And only it was not listed, my lord, because there is not accompanied by IA, my lord. There is no requirement of IA for condemnation of delay in review petition, my lord. This filing section has detained it, my lord. That's why I have informed them that there is no requirement or it will be listed within 10-15 days, my lord.
How do you say that condemnation of delay?
There is the decisions of the court, my lord. There is no requirement for a condemnation of delay in review petition, my lord. In numbers of cases, my lord.
No. Earlier, my lord.
No, not required, my lord.
No, let me know. Earlier, when 226 petition, my lord, review petition, my lord, there is no requirement of condonation. 220 petition is an external jurisdiction, my lord. In that case, my lord, there is no requirement.
In
of
that
condonation.
case, you
226.
file review after 10 years.
No,
Still it will be maintainable.
yes, my lord, the decision is
my
there, my
lord.
lord. But the decision is there, but
There are decisions, my lord.
but subsequently, my lord, that decision has been overruled, my lord. Because that case we have appeared, my lord, that single bench doesn't of this court, my lord, that 226 review application, my lord, there is no requirement of any my lord, conventional petition.
Yes.
But subsequently, my lord, that decision is overruled, my lord.
Okay, after how many weeks?
My lord, Lordship will fix it after vacation. In the meantime, this
No,
petition will
only-
be listed.
No, only thing, my lordship, kindly speak, 80 miles are working from 85, my lord. Order was passed on 2019. They come with a my lord review application in 2024, and matter is pending, my lord. A person is already, my lord, completed 40 years of service, my lord, and their my allegation is this matter, my lord, that this person is, my lord, not appointed conventional.
Yes.
But what one of his case has said, my lord, this is not a forum, I say that, my lord, if a
Okay,
person works.
give a date.
Lord will fix it on immediately after reopening, my lord.
List again on so and so.
No, very my date may be given, my lord.
17th.
I will.
17th of July.
Yes.
Meanwhile, you do what you have,
Lord,
what you have to
Lord,
do.
The last son, my lord, the last son.
Yes, next case, please. It's also review.
Lordship, matter may be possible for the timing. My senior is on legs. Lord.
Timing.
Yes, timing.
No, 4:10. No, Friday, correct.
Well, can it be on Friday, my lord?
The urgency.
Yes, there's urgency, my lord. The 2021 order, my lord. After filing of the contempt petition 2024, they have preferred this review petition, my lord. I am deprived from the regulation with the 1st January 2013, my lord. Some urgency is matter, my lord. Friday, my lord. Can it be?
Okay, list on Friday.
Deeply obliged.
Give the date. As paid for by the parties.
Portland also after Lordship needs a B course, he has some difficulty today, Lordship. Let it take up next week or after vacation, Lordship. Other side also not here.
After vacation. And as paid for on behalf of Mr. P. Kaushik, list the matter again after the vacation or something. Give a date. 23.
Item 50, Lordship, I am appealing from the respondent 1. I have already, the director has already instructed the inspector of school to take some the initiative for promotion, to take the process of promotion, Lordship. This is so it will take some time. The process is initiated, Lordship.
Mr. SMT Chisti Learned
Vacation,
Counsel,
Lordship, may kindly fix.
for the respondent prays for some more time to come up with the up-to-date status. Yes, we forgot list again on so and so.
That instruction may be in the record.
Which instruction?
Just I have placed it.
It's okay.
All right, yes, 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 Lord.
This-
Item numbers 51 to 57.
Here I need some accommodation, Lord. I have already 2 weeks time, may kindly.
No, my lord, what happened in this case, my lord, the petitioner service has been regularized. School has been provincialized, my lord, in the year 2021, under the Act of 17, my lord. Then since then, they have not been paid, my lord. They have been provincialized, but they have not been paid since then. Then I approached this honorable court. Honorable court passed an order to release the salaries, my lord, within a period of 3 months, my lord. In spite of that, they did not pay any hit to it. That is why my humble submission before your losses, let the matter be listed on Wednesday next week, and let her come, my lord, the director, because only the director has been passed a direction to give the to release the salaries of the petitioners, my lord.
So I need some more time, Lordship. I have been instructed 2 weeks time, may
Allocation
kindly be
took
given.
times
Yes.
two
The
times,
process
my
is,
lord.
it will take some time to get the process done, Lordship. Either 2025 matter, Lordship.
Come, my lord,
Either
let her come.
2025 matter, Lordship.
Because in spite of court order, they did not care, my lord. Did
No,
not care
Lordship.
the honorable court
That's
order.
the
my
wrong
lord.
submission, Lordship.
Order has been passed on,
We have
my
been,
lord, lordship.
we have been issuing speaking orders,
21
compliance order in whole lot of contempt cases. Not these are not the exception, Lordship.
Okay, let us see
Either
what.
2025 matter, Lordship. 2 weeks time may kindly be given.
Not 25 letter, 25 matters.
No, let us
This is the
see.
case of 24. And they have not been received after the provincial.
Where is the order? Not-
Order is 20 page, pin 20, relevant portion is lordship, can you pay rules? 23, the next, the director of secondary education lordship got it.
Page
23.
23.
Yes, my lord. second para.
Yes.
The Director of Secondary Education, Assam, shall release to the petitioner's dear's pay the 04/01/2021 as tutors. They pay of the petitioner in the areas since 04/01/2021 shall be released to the petitioners by the Director of Education, Assam, within a period of 3 months from the date of receipt of the certified copy of this order. The Director shall, the month of April 2024, release to the petitioner their current salaries. The areas would be released as indicated herein above. Current salaries also they did not pay, my lord. That is why I approached before your lordships, my lord. And my humble request before your lordship is that let her come to explain why she has not been released the salaries, my lord. Let her come, my lord. School was provincialized long back, my lord, in the year 2021. Then they did not pay any salaries, my lord, since then. And they have approached before these concerned authorities several times, filing their representation. They did not pay any heed to it. Then if it is, why they have been provincialized the school then? If they won't be able to pay the salaries, then why government has been provincialized the school, my lord?
Mr. Chisti, what is to be done?
Let her come, my lord.
Calling the
She
director.
should come
Lordship,
before this court, then she will realize.
Lordship, let me have some up to the instruction, Lordship.
Direction was to release the salary, that's all.
Yes, current salary too, my lord. Current salary also. They are not giving us current salaries also. And at this stage, how my lord petitioner will survive, lordships?
How many respondents are here?
Only direction has been given, only director, my lord, in this case. Because he's the
Director, Lordship had to approach the finance and Lordship, lot of things are there. Lordship, director alone cannot.
No, that's why, no? That's why at least.
That process is going on, Lordship. Kindly grant us some time, Lordship.
That's why that process taken by the director has to be also shown.
Yes, Lordship.
Yes, twice he took time. Even then, she has not taken any process. At least he should submit some process. That process has been taken, my lord. That actually he should submit that process, my lord, today itself. Because he took twice, my lord. He took times twice, my lord. After.
Lordship, this
We'll give one.
My lord, actually,
they
are suffering, my lord. At this today's
not that we are not complying any order, Lordship.
Without having salaries, how people will survive?
There's so many contempt cases
how they
are complying, Lordship.
And if we have done anything wrong, then let the matter sent to the concerned authorities to make inquiry, something like that, my lord. If the school is illegally provincialized, my lord. But it is not done. And why they have been paid, that is also, they did not utter anything, my lord.
Okay, we'll have one more date.
Yes,
all right?
Lordship. In a 20-25 meter, Lordship, I will get.
Oh, percentage.
Uh,
25 matters, but non-payment of salaries, my lord. He said this to you.
Ms. K. Devi, learned counsel for the petitioners, vehemently argues that the direction of this court has not been complied with by the respondent willfully and deliberately, and therefore submits that the respondent should be asked to appear before the court and give an explanation why the order has not been complied with. So Mr. SMT Chisti, learned counsel for the respondent, on the other hand, submits that he may be given one more chance to apprise the court the steps taken by the respondent.
At least current salaries, your lordship can leave us an order.
Considering the submission made. This is a contempt, so we cannot
Yes, yes.
make further observation
Yes,
also. That the matter will listed again on so and so.
It maybe will be added.
I think 3 weeks should do.
Yes. As a last chance, my lord, kindly put this word.
After 3 weeks on so and so, give a date. So,
Page 5, 7, okay.
Oblige.
25-7.
As a last chance.
So if no show cause note, if no show cause reply is filed on or before the next date, or proper instructions received by the learned counsel for the respondent, court may consider passing appropriate order.
Oblige, sir.
Oblige.
Lordship, in the item number 49, Lordship, I miss, my lord. Item number 49,
Yes,
that's not there.
we have adjourned it, I think.
Yes, yes. And B. Kaushik also, he has some difficulty, so.
Yes,
Lordship,
Mr. Kaushik was not there, so I have not mentioned anything, only
My time will
adjourned.
be recorded.
What's your good name?
D.
What did I say?
Non-appearance.
Okay, your good name?
D. Governor.
Mr. D. Gogo appears for the petition. One more line. Yes.
D. Governor.
Yes.
I have taken a step upon the respondent lordship.
Why is it listed today? When did you take steps?
My lord, here I am appearing, my lord.
Sole respondent.
My lord.
Who is he? Oh, you are appearing.
My lord, I am appearing.
What is your
I
instruction?
need some time, my lord.
What was the direction?
Lordship, Lordship, page number 15, Lordship.
Operative portion.
Paragraph number 6, Lordship. The matter is by a regular pension, non-payment of regular pension, Lordship. His honorable court directed to verify the documents, Lordship, pertaining to stipend, Lordship.
As paid for by Mr. P.K. Bora. Further 3 weeks' time is granted to obtain instructions in the matter. List again on so and so.
My lord, I'll bring. Oblige.
May it pleases you, lordship, on behalf of NJ Khatanier, your lordship, I am praying your lordship some accommodation, your lordship. Kindly matter may list on Monday, next Monday.
Okay.
Due to some personal difficulties, he could not be able to attend.
As paid for on behalf of Mr. N.J. Katani, learned counsel for the respondent. List again on so and so.
I'm deeply obliged.
Monday.
Only Lordship.
May I please, your lordship?
Yes.
Your lordship, in this case, step has been taken against respondent number 3 and 4, and the service has been completed, your lordship. So, my humble submission is that matter may be listed for hearing, your lordship.
But no affidavit, isn't it?
Yes,
Who's 3 and 4?
3 and 4 is, your lordship, the Sri Kishan Sarada College and the principal of Sri Kishan Sarada College.
Then you are there.
Yes, for respondent number 1 and 2.
Parties are represented by the respective councils except for respondent numbers 3 and 4. Lavazima Court's order dated 12/6/2025 indicates that AD card has returned back from respondent numbers 3 and 4. In view of above, notice is hereby accepted to be served on respondent numbers 3 and 4. List the matter for admission after the ensuing summer vacation. Parties are at liberty to file their pleadings in the meantime. Not filing, right? Exchange. To exchange their pleadings.
Please, Madam. Madam, the petitioner has filed an IA and on reply, we are filing it tomorrow, by tomorrow, Madam. Kindly this matter be fixed after vacation, Madam.
Milord, I object to it, Milord, because I'm having to come from Kolkata on the way. So the matter, you definitely listed this matter today itself. This main petition is pending for nearly 1 year now. Then they have issued another notification in violation of the objection, points we have made in the main petition. Then, Milord, this IA has been filed for staying the recruitment, Milord. Then by vacation, this recruitment will be over. This recruitment will further violate my petitioner's fundamental rights, Milord.
This IA is filed by you or for this mercy?
I filed this IA, Milord.
IA is for what purpose?
Milord, initially my client
IA is filed for staying the
ongoing recruitment process.
And you have filed something?
Yes, my lord. By tomorrow, we are going to file it, my lord. By tomorrow, we are going to file it, my lord.
File what?
Our reply to the IA, which has
Objection to the IA?
Yes, my lord. Sir. Our objection.
There's a point, my lord, because main petition is pending. So IA is there for preventing the further violation of the points we have made in the main petition. So IA, let this be stayed. Ongoing recruitment process be stayed for the time being.
No.
The respondents have nothing to lose, my lord. I'll have everything to lose. For last 15 years, my lord, I am without any promotion. My juniors have become
How do you say that there's nothing to lose? Well, many people will be involved in that, you see.
Beg your pardon, my lord?
Even on the last, in the last order also, even he have to serve notice to the other respondents as well. And more to that, in the affidavit also, he have made it very clear why he has not been promoted, because there is a committee set up and there is a minimum qualification required. And
then it will be hard in the main petition, Lord. This is IA.
And more to that, my lord, there is no stay with regard to that further advertisement should not be done. That is why we have issued the advertisement in the requirement of the institute itself, because further promotion and this should happen. That is the reason why we have issued this.
Milord, after 8 long months, they have filed a
my
reply.
humble prayer is that.
Milord, now without.
They filed a reply in the main.
They paid the main after 8 long months. Just.
They filed.
Yeah. By this time.
So let it be heard then. Let the main appeal be heard, with petition be heard.
You see, Milord, today itself, let it be heard. Tomorrow. But we have no objection.
Lord, I was just saying, since he have filed an IA, this is a new cause of action which has arisen. Nothing to do with the present petition.
You don't be bothered about the IA.
Yes, ma'am.
If you have filed your counter affidavit in the amended petition, that can be taken up for consideration.
We have filed it, ma'am. We have filed that, madam. Can it be fixed after vacation, Lordship?
Milord, after vacation, by the time, there will be subsequent violation of my client's rights. Milord, already I have been injured. My fundamental rights have been infringed. They are going to do it again with impunity, with your lordship's cognizance of the matter.
It's okay. We'll say it's subject to the outcome. Whatever they do will be subject to the outcome.
Milord, then by summification, his position will be, he will be further, his fundamental rights will be affected further. Let this be stayed, Milord. Let this, ongoing recruitment process be stayed, Milord.
No, since he says this is going to file an objection to this, without filing of that, it will be difficult to pass any order at this stage.
In that case, their inaction is their responsibility, Milord. What I will do? They have not filed in this matter. I have been filed for 15 days back. This ongoing recruitment kindly be, your lordship may most graciously be pleased to stop.
When is it going to be finalized, the recruitment?
My lord, by tomorrow we are filing it, lordship.
No, the recruitment.
Sorry.
The so-called recruitment you're going to make.
Yes,
any dates given? The list of dates, date of recruitment, date of what not, interview, Fiverr, Boise and all that.
At least let them complete, let them not implement this. Let them do all the procedures. But implementation of the recruitment may kindly be stalled, my lord. Your lordship may most graciously stop them from doing another crime.
That has not been reflected.
My lord, I am the petitioner. I am the petitioner of this case. May I say something? Permission, then I will say.
Come. Yes, what do you want to say?
I have joined this institute in 2010. The post what I held now, from that post I have joined from that time. I have the all qualification, everything, and they are depriving by taking illegal process, non-government technology they are using, and in various means they are trying to trap me. They don't want to give promotion. And from 2016, when I applied for professor post and associate professor post both at a time, without showing any reason, they have not shortlisted my name. Then I take the help of NCPC and OBC Commission, SC Commission, and Ministry of Social Justice. And all things I have given. Later on, I do not know what happened. The interview was cancelled. Interview was happened, but everything was cancelled. Later, no promotion was given. After taking interview also, so many complaints I have given there. Everything is there. And now, when I joined in, when I applied in 2017 with government notification, with taking government, non-government policy that government institutions are institute of repute, they are giving this. No, don't go into that. May I explain? So he made an RTI. What was the procedure for consideration of the applications?
All right. See, we'll do one thing. We'll fix this matter for hearing on a particular date.
Yes, sir.
Just
Before vacation,
tell me when will it be convenient for the parties?
Before vacation, Milord? Because by that time they will publish it. Another batch of juniors will be my boss. Institute, there are dean, there are registrar in the faculty. His juniors are now become his students have become his professor. And there is no explanation to the authorities. I mean, neither minister of now ministry is not appearing. Ministry,
All right. You save your argument for the hearing date. Okay. We'll just agree to a date and we'll see what we can do.
What I'm praying is let it be after vacation for a reason that why the IA is there. Let the IA be subject to outcome of the IA, whatever comes. If Lordship finds that no, whatever the process is going on, that is completely violating his right, or because whatever question he is raising, my lord, is there in the same, it is similar to the question which is raised in the.
When the IA is pending, my lord, IA is pending. So let them also keep the pending of the recruitment. Because IA is actually IA is attacking this recruitment process.
We are concerned with the post of professor.
My lord.
Professor in which department?
It is integratedly for the whole institute, my lord. So this because
No, you please come to your IA.
Yeah, my lord.
Annexure 1, page 81.
Yeah. Yes, my lord. Actually, IA, page 82, my lord, of the IA, they have declared so many posts for professor, associate professor, assistant professor. They have not mentioned how many professors and how many associate professors, etc., etc. So, my lord, it has to be considered with an integrated approach for the whole academy.
So petitioner will be concerned with which post?
Professor, my lord, from associate professor to the post of professor. He held the post in 2010. He joined in the post of associate. Now he is still in the associate post.
So recruitment is going to happen in the post of professor, associate professor, then assistant professor, grade 1 and grade 2. Correct?
Yes, my lord. They are going to recruit again.
It's
Prior to this, my lord, there are 25 persons who have superseded him. There has been recruitments. But since his application was not being considered, he refrained from applying. In 2016, he applied. In 2017, he applied.
Please simply answer my question. That's all.
Milord.
See, now we're concerned with how many posts? 4 posts, isn't this advertisement?
No, my lord. If it is total posts are 15 plus backlog 47 posts.
Not the numbers. What kind of post are we concerned here? We concerned with professor, associate professor.
It has not been mentioned in the advertisement.
Oh, it is written here, serial number 1 to 4. Yes, Mr. Counsel, what?
He is concerned with professor post. He is actually wanting to have a professor post.
You're intending to recruit
Yes,
professor,
professor.
then who else? Associate professor also.
Associate professor also.
Then
Class
assistant
two.
professor grade 1,
Yes,
grade 2.
Yes, yes, Lordship. We have in 82, page number 82.
But come to page 82.
Yes, Lordship.
How do you calculate this? Schedule caste 2, then schedule tribe 1.
Yes.
And schedule tribe 2 means what? Against which post?
Yes, my lord, for professor 2.
So,
Yes,
so
associate professor 2.
2.
Yes, it goes in the same line.
So total will be 8.
Yeah, total be unreserved will be 8. Unreserved is 8. Total as a whole, total will be
No,
16.
for schedule caste.
Yes,
Schedule caste, there are 2 posts reserved.
yes, my lord. Schedule class 2 posts.
2
Schedule
posts for
tribe,
what?
2 posts, my lord.
No, 2 posts for which one? Against professor or against associate professor or against professor grade 1 or assistant professor grade 2?
As far as my understanding goes, because the name of the post is written and the number is similar for all. Man. The numbers
No, my lord.
are similar for all.
Wrong. Anyway, my lord, we are concerned with post of professors, my lord. We have nothing against the promotion of the people who are from associate or from assistant professor to lecturer, grade 1, grade 2.
Yes,
Grade-
of course, you cannot be also. You don't want to become assistant professor, isn't it?
My lord,
You are, when you're dreaming of becoming professor, you're not concerned of assistant professor grade 2. No, what I'm trying to understand is because the kind of they divided, number of posts they have divided, scheduled tribe, scheduled caste, 2 posts, 1 post, 4 posts, 1 post. Now, for example, economically weaker section, 1 post.
1 post.
1 post means what? Was 1 post from professor also, associate professor also, or assistant professor grade 1 and grade 2? How you have divided this?
That is not very clear actually.
That is very opaque, my lord. This is only one example of the
Otherwise-
opaqueness. There are, in the entire process, there are so many inscrutabilities.
Anyway, you should be ready with the explanation with this. So when do you agree? Come to an agreed date.
My lord,
We'll thrash out the matter
my
for
lord,
hearing.
any date, my lord, for the timing, post of professors be stayed out of this recruitment. My lord, this is my humble prayer, my lord. Let them also get what they deserve, because already I have written so many notices, but not a single notice has been replied to. I can show you, my lord, but this is a glaring example of the institutes, so many famous institute of the.
Don't fill up the post of professor.
Yes,
Proposal of the
professor,
IM.
let it not be implemented. Let them go on with this. Pending the hearing of the matter, let the professors.
Apart from professor's post, other post you may go ahead. Professor post, let it remain.
My lord,
Let us go as on today.
Yes, sir.
my lord.
Till the next date. And the next date, if parties agree, we can thrash it out. Meanwhile, if you want to file a WO, you file your objections.
My lord, let it be after vacation, my lord. Now, since he will not be having an objection to that right now, since there's a status quo order.
Parties
date
are
after.
represented by the respective counsels. Your good name?
K. Vishwakarma, my lord.
Mr. K. Vishwakarma, learned counsel appearing for the respondent.
5, 6, and 12, my lord.
5, 6, and 12 submits that.
On behalf of Mr. S.P. Chaudhary.
Oh. Mr. S.P. Chaudhary,
Yes.
learned counsel appearing for the NIT, Silchar,
Yes, Lordship.
submits that he'll be filing the objection by tomorrow.
It is otherwise ready, Lordship. You can serve him a copy. Whether he has been served a copy?
No, he told me that he's filing it tomorrow.
Yes.
Then let it be taken up.
We'll fix it.
I can take it now. We can hear it tomorrow.
What I was thinking is that instead of, like going for the IE and all that, we can go for
Yes,
a,
Lordship, this matter can be disposed
we
of.
can,
Yes.
we can consider disposing it out.
Exactly, exactly. Basically, the grievance that has been expressed by the petitioner, he has not participated in the proceeding. Because after 2017-18, he had to participate, and that is the basic stand that we have taken on an affidavit in opposition.
There is no impugn order. There is no order of rejection. Previously, when he was rejected, that was at that point of time, he was not qualified for that post. Now, if he claims himself to be qualified, he can participate. If he is not
This
participating.
is not true, my lord. He actually, one man rejected his application without
That
any.
was a long back, Lordship, 2012 matter.
So long back crimes do not.
He is agitating
Even,
the
my lord,
issue.
even after 1 year, crimes stay and there is no limit to this thing. Time limit.
So you agree to a date, we'll fix a date and for
Yes.
hearing.
Any day after vacation, Lordship, or next week, Lordship.
Meanwhile, you don't fill up the post,
Then
we'll
next
have
week,
it.
then next week, Lordship.
Next week will be perhaps, I don't know, will be
My
a
lord, I
motion
am
league.
willing to come all the way from Kolkata, my lord.
Then day after
So,
tomorrow, if he is.
Client is suffering, client is.
No, if he is
suffering
coming from
both
Calcutta.
Salary wise, promotion wise, and his self-esteem wise. His students have become his boss. And without any reason, they can.
No, we have sufficient
For the
reason to
typing
expect
period,
everything.
Mr. Post may not be.
Lordship,
filled
can you
up.
fix it up day after tomorrow? Whatever the grievances, we have expressed everything in our affidavit in opposition. So Lordship will be in a position to
Really, if we
adjudicate
have
the
to-
issue.
I have to go to.
There is no
customer.
merit in the
Another hotel expenses and everything will be borne by him. Look at him, he is suffering like anything.
Last
So tomorrow, now,
times we have taken time.
now I am accepting the objection.
So
and
many
tomorrow
matters are
this will-
pending. This is not the only matter which is pending. Day after tomorrow, Lordship. Since tomorrow will be filing the affidavit in opposition with regard to the IA.
Tomorrow I will be objection.
With regard to IA, so it will take 1 day time at least to be taken on record.
12th June maybe?
Huh?
12th June?
Day after tomorrow.
No, actually what is it?
Today is 16th June.
16 June.
12th
12
July,
to
see?
12th July, no, 12th July. কবে ভ্যাকসিন স্টার্ট হচ্ছে কবে?
Vacation কালকে করেন please. না পরশু day after tomorrow.
Oh, you have to after the vacation.
Day after tomorrow, tomorrow is having problem.
I don't have any problem. Only thing is that file an affidavit.
Maybe it may be done tomorrow. Maybe. So that I can go back to Kolkata.
Tomorrow we already have a list.
Maybe kindly, your lordship may please fix it after vacation, but for the timing, professors.
No, then I have a question with regard to that lordship. Because at the time of issuance of notice of motion lordship, that prayer was rejected. He is reiterating the same prayer. At the time of issuance of notice of motion in the main petition, that prayer was made. Interim prayer was not considered at the relevant point of time, lordship. Because there is no impugn order.
My lord.
Without participating in the selection
Post of
process, now
professor
he
be
wants
kept
to
in
stall the
abeyance
process.
out of the ambit of this recruitment process. Otherwise, then you will not, anytime.
He wants to
your
stall the
lordship
entire
will-
process for no reason.
I'm not stalling entire process, only professor. Only the post of professors.
We'll have it on Thursday.
Yes.
Thursday. Release the matter on Thursday.
All right.
I think there are few matters left in the admission column. Yes. Yes, I think we'll have to give a date for this.
Yes, my lord. Item number
Time is-
26 and 27, my lord. Before vacation, my lord. By order, we have mentioned this.
You give a date. Give a date after the vacation. I'll leave it to you. Okay. You get in touch with the court master. She'll
Yes,
give you a
my lord.
date.
Lordship, interim order needs to be extended.
Of course, whatever interim order is there, that also you indicate necessary orders.
And Lordship, in 28, the difficulty is that since I have an interim order wherein I was reinstated, but I'm not getting salary since September last. So I have an urgency on with that respect. In item number 28, there is an interim order of the transfer. There's an interim order, transfer order was stayed. I am not allowed to join and I'm not getting salary.
You'll get a date. Today is not possible.
Not
so-
today, Lordship. But Thursday, if Lordship allows me.
I don't-
Because the difficulty is he's not getting the salary. He's not being allowed to join in spite of an interim order. The staying this transfer order. That's the difficulty. And it's a very small matter also. It's not just it'll be just around 2-3 documents which I need to show. So Thursday, if Lordship allows me. That's my humble prayer.
We'll see. It depends on the number of cases listed on that day. You see.
I just
Because
have a-
like today itself, if there are 60 plus matters
Yes,
listed.
Lordship, I understand. I
not
just try
possible.
my luck on Thursday. I'm just saying, Lordship, I'll try my luck on Thursday if
We'll
Lordship.
see. Anyway.
Deeply.
I have item 24. Pension